Good morning. Welcome to the PSC. We'll go live in about 2 minutes. Please have your microphones off. Good morning. Welcome to the Maryland Public Service Commission. We are on the record in docket number RM70. This is the rulemaking session to update regulations in the Code of Maryland Regulations regarding Title 20, subtitles 51, 53, 54, and 59. On October 20th of 2020, the Commission issued a notice initiating this rulemaking session regarding retail supplier consolidated billing, and we'll be hearing from interested stakeholders over the course of the next 5 days regarding a number of proposals that we've received, as well as comments from the various interested parties. We'll begin this morning by taking the appearances of the interested parties, beginning with the state agencies and commission staff.
Good morning, Mr. Chairman. Annette Garofalo on behalf of staff, together with Benjamin Baker and Michael Zhang. We also have Drew McCullough of the Electricity Division and Afton Hauer of the Telecommunications, Gas, and Water Division available should there be technical questions regarding the treatment of competitive gas and electricity supply that are relevant to but outside the scope of the proposed supplier consolidated billing regulations being considered today.
The Maryland Energy Administration.
Yes, good morning, Commissioners. Anka Schneier on behalf of the Maryland Energy Administration, and I'm joined by Landon Farrig, Assistant Director of Policy for MEA.
Maryland Office of People's Counsel.
Good morning, Mr. Chairman and Commissioners. Jacob Auslander on behalf of the Maryland Office of People's Counsel.
We'll now take appearances from retail supply interests, beginning with those who I will refer to throughout this hearing as the petitioners, led by NRG Energy.
Good morning, Mr. Chairman, Commissioners. I'm Brian Green, and I represent the petitioners. We are 6 supplier entities, and just for the record, it's NRG Energy, Interstate Gas Supply, Inc., doing business as IGS Energy, Just Energy Group, Inc., Direct Energy Services, LLC, NG Resources, LLC, and Vistra Corporation. And with me today and this week will be Leah Gibbons from NRG Energy and also John Schatz from Vistra Corp.
We'll next turn to DECA Energy. We'll turn to SFE Energy and Statewise Energy.
Good morning, Mr. Chairman and Commissioners. I'm Stacy Rantella here on behalf of SFE Energy Maryland, Inc. and Statewise Energy Maryland, LLC.
WGL Energy Services. Are there any other retail suppliers that wish to make an appearance? We will turn to the utilities now, beginning with the Exelon Utilities.
Good morning, Your Honor. Matthew Seegers appearing for Pepco and Delmarva Power.
Good morning. Christy Ravenel on behalf of BGE.
Potomac Edison.
Good morning, Mr. Chairman. Jeffrey Trout here on behalf of Potomac Edison. We have 5 subject matter experts available to assist the Commission and the parties with these hearings this week. They are Nora Arnold, Stacy Cochran, Shelley Dye, Valerie Hess, and Kathy Lindsay. They are all available online.
Thank you. Washington Gas Light Company.
Good morning, Mr. Chairman and Commissioners. Robert Kane on behalf of Washington Gas Light Company. With me today, I have Tina Ward, Teresa Wall, Andrea Mills, Bacha Tacoan, and Anthony Murdoch.
Thank you, Mr. Kane. Are there any additional interested parties that wish to participate in the rulemaking that have not entered an appearance? Mr. Michael Sergeyev?
Michael Sergeyev, DECA Energy.
With DECA. Thank you, sir. If you could please mute your microphone. And if all parties could please mute unless not speaking throughout the rulemaking session. Obviously, supplier consolidated billing is not a new concept. Back in 1999, with the passage of the Retail Energy Choice and Competition Act, the Commission stated, actually the General Assembly stated, that competitive billing should begin on July 1st of 2000, so 20 years ago, and that is codified in POA Section 7-551A. Obviously, in the past 20 years, our supplier industry in the state of Maryland has continued to grow, with many entrants now participating in the retail supply market, both for electricity and natural gas. On May 7th of 2019, we issued an order, and I would say it was a historic order, authorizing the transition to supplier consolidated billing, establishing a timetable and providing some initial determinations with respect to what this commission expects to see in terms of progress and in terms of what this rulemaking will look like. We made some additional initial decisions to not allow retail suppliers to have access and the ability to terminate a customer. We determined that that was best left for the utility for a number of reasons. Approximately 2 years ago, the petitioners in this case filed a petition for a rulemaking to codify in our regulations the rules that would govern retail supply consolidated billing, and we'll be hearing those over the course of the next 5 days. In reviewing all of the proposals, particularly the regulations submitted by the staff, the petitioners, and the Office of People's Counsel, we recognize that much work has gone into this, particularly over the past year, with parties meeting once a week, if not several times a week, to develop these regulations. The Commission also recognizes that many of these proposed regulations are non-consensus items. And most of those non-consensus items relate to the treatment of payment-troubled customers. And as staff stated in its comments, perhaps this is the greatest and only real risk to supplier consolidated billing going forward. And it does trouble me that we will be spending most of this week on issues pertaining to what happens when customers do not pay their bills. In a perfect world, if everybody paid their bills, we could have dispatched with this rulemaking session in probably one day or less. We will be tackling a number of issues over the past 5 days. I know that the staff has provided the commissioners and all the parties with a proposed agenda. I think the agenda is very detailed and very aggressive as we proceed in 4-hour blocks with the exception of Wednesday. I plan to call 2 breaks today, one around 11:30 and one around 1 o'clock for about 10 minutes. We won't have a lengthy lunch break throughout the week, but you'll have enough time to grab something to eat during the course of this rulemaking session. Staff will lead this session, and we will walk through these issues one by one. Parties will have an opportunity to respond, and then commissioners will have the opportunity to ask all of the parties questions. Because of the extent of the changes to these regulations and the fact that we have 3 competing sets of revised regulations, I do not anticipate that the commissioners will call a vote, an official vote, at the conclusion of this rulemaking session. We will take the time necessary and issue a written determination after this rulemaking session adjourns. That said, parties to this case will hear from commissioners, and notwithstanding the fact that we won't be taking an official vote, commissioners are free to and will likely provide their views and opinions on the regulations before us. If parties wish to speak, I can see up to 24 parties on the screen. I would ask that you either raise your hand or give a wave, or simply turn on your microphone, and I'll see that you're in line to speak. In the unlikely event you're hiding out on another screen, feel free to just use a little audio to let me know that you'd like to be recognized. With that, I will recognize staff to give us a high-level overview of where we should expect to go over the course of today and the next 5 days. Good morning, staff.
Good morning, Mr. Chairman and Commissioners. I am Benjamin Baker on behalf of staff. Thank you for the opportunity to present these regulations to the Commission today. I would like to begin by thanking and recognizing the members of the work group for their time and effort to develop these proposed regulations. Staff proposes to cover a broad number of topics and extensive proposed regulations this week. Ms. Garofalo and I propose to a plan for the following. Today, we plan to focus on 5 policy issues within the SCB proposal, which represents areas of some contention. If time permits, we will cover additional policy issues that are scheduled for Tuesday. These policy issues are related to customer eligibility and purchase of receivables, which I will now refer to as POR. If the Commission chooses to provide guidance upon these topics today before reviewing the proposed regulations, it may assist with the review process if further refinement of the proposed language is possible. Staff proposes to review the revised regulations with the other topics and proposed regulations related to enrollment in POR tomorrow. For the remainder of the week, staff proposes to walk through the proposed regulations and disagreements with those proposals simultaneously rather than separately, as with the initial 5 policy issues. Mr. Chairman, with your permission, and if there are no questions, I propose we proceed to the discussion of the issues.
Please proceed unless any of my fellow colleagues would like to make any statements at the outset. Mr. Baker, please proceed.
Yeah. The 5 topics we would like to cover today with the Commission are customer eligibility and supplier consolidated billing, competing purchase of receivables proposals, payment posting, and bundled and unbundled charges, including both their treatment and payment posting and marketing. If time permits, I would also like to cover topics related to limiting arrears repurchased by the utility and treatment of customers who are on payment plans or on budget bills at time of switch. Before we start reviewing these topics, I would like to give the Commission a 10-minute high-level overview of the structure of SCB to help illustrate the scope of the process for a customer on SCB from enrollment to drop, and to pinpoint where large policy decisions will need to be made. Filed with the proposed regulations were business process flows. I will be using pages 1 and 4 to help guide this discussion. In the interest of time, I would request that we cover questions related to these processes when discussing the issues later in the day. But of course, if you have questions or need clarification, I will be happy to oblige. First, please direct your attention to page 1 of the business process flows, boxes 1 through 5. This process illustrates a customer switching from utility consolidated billing to supplier consolidated billing. The enrollment process for a customer choosing to participate in SCB will be similar to a customer on utility consolidated billing. The supplier will go through the traditional process of acquiring a customer, but they will include additional disclosures on the contracts. One of the issues of contention that we will discuss today will be the marketing of bundled and unbundled charges within those contracts. Once the supplier has contracts with the customer, the supplier can enroll the customer. Under the proposed regulations, there are no restrictions upon a supplier enrolling a customer. Instead, to ensure the supplier is informed of the customer's financial risk, the supplier will be given additional information about the customer's arrears history and current status of the payment arrangement. This is where I will note the second area of disagreement we will discuss today, which is parties have proposed alternative regulations that would implement eligibility requirements upon customers. Under the proposed regulations, the supplier will request pre-enrollment information from the utility and then choose to enroll or not enroll the customers. As shown in boxes 6 through 10A, if the customer is enrolled with a SCB supplier, the customer will receive their enrollment notices, and there will be a process for the utility to return a portion of the customer's deposit. At that point, the customer will be receiving commodity service from the SCB supplier. Now I'll move to the customer's bill experience after switch, which is covered on page 1, boxes 11 through 18 of the process flows. Under the proposed rules, there is no bill on switch. This means that customers will not receive any bills from their supplier until after the utility reads the customer's meter at their next scheduled meter read. This process will be slightly different for gas and electric, so I will highlight the two differences for the Commission to be aware. For electric, the usage will start to accrue towards the new supplier once the enrollment is confirmed. This is due to the 3-day switching rules that we have in place today. This means for electric customers, they will receive at least 2 bills in a month when they switch to or from supplier consolidated billing, and both bills will likely come at nearly the same time. One bill will be from the previous bill provider for all charges up until the date of enrollment, and one bill will come from the new supplier for all charges after the date of enrollment. It is possible for an electric customer to receive more than 2 bills in a month. Once again, this is because of the 3-day switching rules, if a customer switches more than once in a month between SCB suppliers. For gas service, the customer's usage will only start to accrue towards the new supplier at the first of the next month. This means customers' commodity with a new supplier will not begin until the first of the month. The customer will still likely receive 2 bills in a month, since the meter reading cycle will likely not occur on the first, but it is unlikely that the customer will receive more than 2 bills within the same month. As with electric customers, gas customers will still receive 1 bill from the previous commodity provider for all charges up until the first of the month, and 1 bill from the new commodity provider for all charges after the first of the month. If that previous billing provider was the utility, when they will issue a final bill to the customer. If the customer does not pay the utility in full, then the utility may continue billing the customer until such time that the customer pays the bill or the customer service is terminated. At that juncture, one of the issues we will need to discuss will be the treatment of customers who have a budget bill at that time of switch, or if that customer has a payment arrangement, which we'll discuss today, and with which there is also disagreement within the group on. Operationally, the utility will send their usage, bill messaging, and charges to the supplier to print upon the bill. This process is expected to be bill ready. Bill ready, for clarification, is effectively a customer, the utility will provide the charges to the supplier already calculated. They will not be providing their rates to the supplier. So all their charges will be pre-calculated before going to the supplier. Supplier will print this information on the bill and send it to the customer. Under the proposed rules, there is no limit on the duration a customer has to pay a supplier bill. And this will be agreed upon in the contract with the supplier. But to ensure utilities and non-SCB ratepayers are not penalized by a supplier's bill duration choice, the supplier will purchase a utilities receivables 23 or 28 days, depending on if it's a non-residential or a residential customer, after the utility has sent an invoice with their charges to the supplier, regardless of a supplier's bill window with the customer, which is shown in box 19. At this point, a customer is now fully on supplier consolidated billing and will be receiving one bill from the supplier. Going forward, until the customer is no longer with the supplier, boxes 11 through 19 will remain effectively the same for the entire duration. They will continue to receive a bill from a supplier for the supplier and the utility charges. They should note if the customer did not fully pay their final bill to the utility or the previous supplier consolidated billing supplier, the customer will continue to be billed by these entities until such time as the customer's charges are sent to credit and collections, and in the case of a utility service termination. At this point within the process, the large issue that we will be discussing today will be the payment posting of partial payments received. Under the proposed regulations, a pro rata approach is proposed. There is a specific treatment of bundled charges to require them to be unbundled or else paid last. And also, it is envisioned that a supplier will be allowed to have gas and electric from separate utilities on their bill. All of these issues we will need to discuss today, as there was non-consensus on these issues within the work group.
And Mr. Baker, if I could pause you there just for
Yes.
one moment. I know that staff filed all of its business process flows and procedures in a number of very detailed charts. I think for the benefit of our YouTube viewers, if we could pull those charts up while you're speaking, that may be helpful. And as you proceed, if you tell us what page of the chart you're on, we'll have the host advisor present that.
Of course. Please be given sharing capabilities. Thank you. Molly, can you please scroll up to page 1? Or 1A will suffice. Let's see, where was I at? At this point there. Okay, so after box 19 here, which is where I was just discussing the payment post. So basically at box 19, the supplier will receive the customer's payments. And if it's a partial payment, they will walk through the payment posting structure that we will be discussing today, in which there is significant dispute. And if it's not if there is no dispute at that point, or if there's no partial payment, there's just a full payment to the charges. And after that point, the supplier will purchase the utilities receivables in full. So now I will focus on two. There are multiple outcomes that could occur, but I'll focus on two predominant areas for a customer who is at the end of their time with a supplier consolidated biller. One of these is the SCB customer is leaving the SCB supplier to go to UCB or another SCB supplier. Alternatively, the customer could be a poor paying customer and they could be facing a drop for non-payment. I will start with the customer switching away from an SCB supplier to a UCB supplier. The process of switching away from an SCB supplier is very similar to the discussion I just walked through on page 1, which is shown here. only the customer is leaving a SCB supplier and not the utility. The nuance in this scenario is the customer will receive a final bill from the SCB supplier if the customer fails to pay this, which could result in the distribution debt being returned to the utility after 2 collection notices have been sent. Once the utility receives this debt, the utility may bill the customer for this debt and pursue service termination, so long as the utility follows all the prescribed termination rules. A variation of what I've just described is shown on pages 2A and 3 of the process flow document, but I'm going to now be switching to page 4 for the drop for non-payment customers. In a scenario where a customer is dropped for non-payment, the customer must be provided with 3 to 5 days notice, depending on if the customer is a non-residential customer or a residential customer. Once this time frame has passed, the supplier may drop the customer back to SOS or sales service. The supplier will still have to follow the final bill process. During this time, the supplier must provide the customer with 2 notices, and one of those notices must occur 15 days before the supplier returns the utility's arrearages. Once the supplier...
Mr. Baker,
yes.
Do you mind kind of pointing out where you're at so I can follow?
Of course. Of course. Yep. So if we go through, so following steps 1, 2, 3, 4, and 5, that is the drop for non-payment notice. And so the customer has missed a payment to the supplier. One of the discussions within the work group was, should there be a mandatory late payment notice? It was determined optional on that issue, but the supplier would have to send a drop for non-payment notice to the customer, which will detail out, you need to pay us or else we're going to be returning you to the utility. And we'll be discussing those notice requirements this week. If the customer pays in full, great, they'll stay with the supplier and we'll keep going. If the customer does not pay in full, the supplier may then effectively drop the customer back to the utility. But I guess here's the nuance to pay attention to, is that because the utilities do not do a bill on switch and they will not read the meter until their next scheduled meter read, there will be a delay between when the customer is dropped back to the utility and when they receive their final bill from the utility. And so this drop process is detailed out in boxes 7, 8, 9, and 10. And so once the utility receives that customer back, they become responsible for the charges after the date of drop. And so they will continue to bill that customer. And so for all charges going forward, they will bill that customer, but they will not receive the customer's arrears back at that point. Instead, there will be a delay until the supplier is able to send their final bill and attempt to collect, which will be detailed out in the boxes that are 11 through 20. And so basically in that process, because per the commission's order, there was a requirement before the supplier could send the bills back, or sorry, not the bills, the debt back to the utility, they had to undergo good faith collection efforts and also send the final bill. And so the good faith collection efforts that the work group arrived upon were 2 collection notices, one which could come with the final bill, but one had to come at least 15 days before the supplier returned the debt to the utility. And so at that point, the supplier will sell their debt, the distribution debt, back to the utility, and the utility can start billing the customer for that. And if the debt is eligible for service termination, then the utility may pursue service termination against the customer, which is detailed in boxes 21 through 25. The supplier, once they return it, will be able to pursue credit and collections against the customer, but that will be there for any debt that was not returned to the utility. One other nuance to be aware of in here is the work group did not propose any there is a competing discount rate proposal that we'll be discussing today, but since the work group was focused on the part of the order that discussed the ability to return arrears and the zero discount rate, the parties came to an agreement that some sort of limit should be on the distribution debt returned to the utility so that it does not grow too large while under the supplier. And so this is an age-based limitation, and so that limitation though would take effect around box 19 or 20 based off the date of invoice. There was another limitation that came up during the course of our discussions based off of different parties' interpretations of the commission's order, based on if a customer is still with basically the customer's status with a supplier. And we'll be also discussing that either today or tomorrow, but effectively what that boils down to is, can a supplier return a debt to the utility if the customer is still receiving some form of commodity service from the supplier? So if the customer is still with the supplier, but they have a new contract under UCB, the proposed regulations would not allow that. The alternative at that point, but the alternative could be that if the customer is no longer with the supplier, the debt can be returned so long as the supplier is not providing the bill. The other alternative interpretation that was put out there was that the debt could never come back to the utility unless the customer was back on SOS or sales service. But the proposed regulations as they are structured now propose that the customer's debt can be returned once the customer is no longer receiving commodity from the supplier. That would be my overarching discussion of SCB. There are other issues at hand this week that we need to discuss, such as the notice requirements, call centers, licensing. But from an operations perspective, especially for our discussions today, I wanted to give you this high-level overview so you could see how it worked from start to finish. If there are additional questions, I'm happy to take them and explain it. But otherwise, we can start moving into the specific issues where we will be able to discuss each of these items more in depth and their ramifications throughout the proposed regulations.
Thank you, Mr. Baker. That's a good overview. I think these charts that you've created fully show the complexity that we're going to be dealing with over the next few days. If we don't need the charts up any longer, we could take them down. Mr. Baker, is the plan to just begin to discuss the first major issue?
That would be the plan. So yes, I would propose, Mr. Chairman, that we start to discuss customer eligibility, which will be led by Ms. Garofalo.
Customer eligibility is a threshold issue in the conduct of supplier consolidated billing. And the consideration is whether there should be any customer qualifications that must be met by a customer prior to being allowed to contract for SCB with an authorized SCB supplier. Various suppliers, utilities, and the Office of People's Counsel advocate for limitations against participation by customers with poor payment histories, including those with utility payment plans. However, it's staff's position that in enacting the Electric Choice and Competition Act of 1999 and the Natural Gas Supplier Licensing and Consumer Protection Act of 2000, the broad terms for participation in retail choice were set. These acts contain no blanket exceptions for customers with a history of arrearages, late payments, payment plans, or receipt of energy assistance. Likewise, nowhere in either statute is there an indication that the type of billing offered was intended to affect a customer's ability to participate in choice. The Commission has been consistent in giving retail choice customers the option of choosing the billing entity and the type of bill to be received. Even in the Commission's order directing implementation of SCB, the Commission found that it is part of the competitive market for a customer to shop among billing methods, even though the Commission would not obligate a supplier to offer a customer a specific billing method. In light of the statute and the Commission orders, it is staff's position that foundational to the offer of SCB are the principles of contract law, with the responsibility for agreeing to mutually acceptable terms being that of the contracting parties. For these reasons, the ability to participate in SCB billing should not be restrained through Commission regulation and enforced through EDI and XML transaction, which is the proposal before you. In recognition of the value of payment history to all retail suppliers, including SCB.
Commissioner Herman, you're having a problem with your audio?
Yeah, I think, okay. Ms. Garofalo, can you hear me now?
I can.
Okay. Give me your statutory citations, please.
I'm citing to the entire statute in that there is nothing in the statute that precludes participation by a customer, nor is there anything that requires a certain kind of billing or other kinds of issues that have been cited by the as reasons by the various parties.
So you don't have any citations that talk about billing at all in the statute?
The statute does not say allows for billing, but it allows for supplier consolidated billing, but it does not address the customer requirements.
Okay, and so where's the supplier consolidated billing reference that you just made?
Well, I'll have to find it. I don't have it in front of me, but it is within the electricity supply.
That's fine. You can let me know later. So you don't have any specific statutory references in your prior discussion then? You're just, in your view, going with the intent of the statute with respect to customer eligibility?
That's correct.
Okay. All right. Thank you.
I think I was just pointing out that those were the reasons, and I'll find that for you, Commissioner Herman, that the ability to participate in SCB billing should not be restrained through Commission regulation and enforced through EDI and XML transactions. I did want to point out that would be the way in which there would be an enforcement of this particular regulation. So in recognition of however, staff understands that this could be a problem for suppliers, and in recognition of the value of payment history to all retail suppliers, including SCB suppliers, staff proposes additional pre-enrollment information that would allow SCB suppliers to make informed business decisions that consider the amount and age of a potential customer's arrears and participation in a utility payment plan. These items should enable the SCB supplier to make informed decisions when determining whether to contract with a potential customer and to determine whether a potential customer presents an undue risk. And that's staff's basic rationale behind our proposal.
Thank you. I recognize that this is as close to a consensus proposal, with the exception of staff, of any that we may be reviewing today. Do any of the other parties wish to speak briefly in opposition to staff's position?
Good morning, Mr. Chairman. This is Jeffrey Trout. I wanted to speak briefly to staff's statutory argument because it is not an argument that we addressed previously. So I'd like to speak to it now, if I might, briefly. First, I agree with your observation, Mr. Chairman, at the beginning of today's hearing that the statute contemplated from the outset that various forms of competitive billing, of which supplier consolidated billing is one, could and would be pursued. I also agree with Ms. Garofalo that there is no specific discussion in the statute as to how that would work and what, if any, limitations would be placed on it. There is nothing that says there are limitations. There is also nothing that says there are no limitations. From those two facts, I conclude that the Commission has the power granted by the General Assembly to adopt appropriate regulations that are necessary to make a form of competitive billing that the Commission finds is appropriate, make it workable. Right now, all the parties, with the exception of staff, are saying that they can't figure out a good way to make supplier consolidated billing work at this time. And I want to underline at this time, because this is something that could change later depending on our experience with making supplier consolidated billing function once it's launched. But at this time, all the parties agree that you need certain eligibility requirements in order to get this process launched. That the Commission has the power to adopt regulations necessary to achieve that, I believe is self-evident. But if you want to look for parallel evidence, you can find it in COMAR. Throughout COMAR, there are restrictions on a customer's ability to get utility service, not just supply, but their basic distribution service. The Commission already has rules that say, for example, the customer has to pay their bill. I think the rule that would be most on point as a parallel to these, for the time being, restrictions on eligibility for supplier consolidated billing would be at COMAR, and I'm going to got my red book here, Title 20, Subtitle 50, Chapter 4, so 20.50.4.01-2, and in 01-2 of 2050 OFAR, there are a whole list of rules of circumstances approved by the Commission in regulations where the utility can deny service to customers applying for service under it's a whole set of circumstances. Prior unpaid bills, misrepresentations, the whole subject of co-occupancy. There are 7 different circumstances just in that one provision of the regulations where the Commission has adopted a rule that says customer can't get any service until this situation is rectified. So the Commission has the power. The Commission has exercised that power with respect to not just a form of billing, but overall utility service. I believe that illustrates that the Commission has the ability to adopt regulations here that are needed in the view of every single party except staff, needed in order to make supplier consolidated billing conceivable to launch at this time. And that would be my response to staff. I don't want to minimize staff's concern for the statutory scheme. I think it's laudable. I don't want to suggest that if the commission adopted eligibility rules now, that they would be necessary forever, because that may well not be the case. But staff's argument is, as it boils down, is the commission doesn't have the power to adopt limitations. And I respectfully suggest that the commission does have that power, and that the analogous power with respect to overall service is already well established in COMAR.
Thank you, Mr. Fisher. Mr. Green, if you briefly would like to make remarks.
Yeah, I will be very brief. Brian Green for the petitioners. I want to comment on two things. One, just to say something that I want to say because I may not say it again all of this week, which is that I 100% agree with everything Mr. Trout just said. And just to add to that and to clarify, the eligibility requirements do not preclude any customer from shopping. They can still take UCB. They can take dual billing if there is a supplier that offers dual billing. And what we're saying is to take SCB, you must have an almost clean slate, right? Not even a totally clean slate, because you get 20 days to pay and then you're 30 days in arrears. And if you're in that window, you can do it. And if you're not in that window, get in that window and then you can take SCB. Petitioners would, in addition to the citations that Mr. Trout provided in 7-511B, there's nothing in 7-511 which says that every customer must have competitive billing allowed for them, but specifically B, the commission shall adopt regulations or issue orders to implement this section. We think it is within the commission's sound discretionary authority to create reasonable eligibility requirements, which is in the best interest of the success of the SCB program. The other thing I want to add from a factual and pragmatic and realistic, we submitted voluminous comments in October and on December 4th. But with respect to staff's proposal on there shouldn't be eligibility requirements, suppliers can get the pre-enrollment information with the customer's consent. And while we appreciate that, and certainly more information in the pre-enrollment stage at any time really is a good thing. And suppliers, the more data and information suppliers can get their hands on, the better. But merely allowing for the pre-enrollment information, again, while helpful, is not the best solution here. And just a word about the pre-enrollment information. First of all, it's hard to get the info, the information, because you have to have the customer's account number in order to get the pre-enrollment information, which interestingly, one of the data points you'll get is the account number. So you have to get the account number to get the account number and everything else that comes with it. So we think that's a COMAR utility issue that is outside the scope of this proceeding, but I wanted to make sure that I pinpointed that. And then second, also, it can take a day or two to get that pre-enrollment information from the utility. And if you're trying to enroll a residential or small commercial customer, that can create a serious timing problem when you're talking to a customer and want to move to finalize the contract, and you don't know if they qualify yet. So we believe that at the end of the day, given the financial risks involved and all of the other things, both from a legal and practical perspective, that the alternative proposal favored by everyone but staff and these reasonable eligibility requirements is the best way to get this program off the ground.
Thank you, Mr. Green. Obviously, the process of promulgating new regulations is to ensure that we have a workable process at the end. At the outset, I mentioned that while the commissioners will not be voting on the actual regulations during the rulemaking session from the bench, and will issue an order at some point after, we may provide input along the way. And this is one area where it's a relatively easy decision for me to provide some input, and I look forward to the questions and thoughts of my colleagues. But if we do have payment trouble customers in this program at the outset, I don't see either the short-term or longer success of consolidated billing by suppliers. I think 7511B, Mr. Green, is on point. It does give the commission wide jurisdiction and ability to set forth regulations regarding customer eligibility. And I agree with the petitioners, the utilities, and People's Council with respect to this issue. Commissioners are invited, but not required to share thoughts on this issue.
I'll just quickly say I agree with everything you just said, and agree with the, I guess it's, yeah, the petitioner's joint utilities PE and OPC position on this item.
I have a question for Mr. Trout. Mr. Trout, is there any concern that this will encourage cherry picking of only the best paying customers? Do you have a concern with respect to that?
Commissioner, that possibility exists whether this regulation is there or not. If we have eligibility requirements, we know what they are. They're categorical, and we can manage around them. As opposed to if eligibility is left entirely amorphous and discretionary. So the short answer is we have a concern. It's a phenomenon that is going to exist no matter what, and we'd rather know what the rules are so we can manage it.
Okay, and under your view, these are starting out regulations so that we can get supplier consolidated billing, and if we do see a serious problem with cherry picking or something like that that causes payment challenge customers to end up bearing what could appear to be bearing more costs of the associated with utility service than good paying customers, then we can address that in the future, right?
Absolutely. Not only can you, I would hope that we would all work together to address that. Yes.
Okay. Thank you. Thank you, Mr. Chairman. I tend to agree that, we have to start somewhere, and this is with all of the parties in agreement with the exception of staff. I think this is probably the best way to go for the time being. And if we need to make changes in the future after it gets going, we can do that.
So I had a question for either Mr. Green or Mr. Trout. And I'll use the language we've been using this morning in terms of the concept of finding the good paying customers, if you will. The way the process works now, if a customer is attempting to sign up with a supplier and you're able to get the pre-enrollment data to find out if they're eligible, so to speak, that takes, as Mr. Green noted a few moments ago, a couple of days. So how is that going to be supportive of the proposal that all of the other parties except staff are supporting? Do you still see yourselves able to enroll customers? And I guess this is more to Mr. Green than to Mr. Trout, but do you still see yourselves able to complete enrollments in a fairly timely manner if, even for good paying customers, you have to wait to get information about their payment history before you're able to complete the enrollment?
Right, so I'll field that. Thank you, Commissioner. With the eligibility requirement, the emphasis on pre-enrollment information is less important. And the way that the rule was set up was that the pre-enrollment information would allow the supplier with customer consent to obtain the arrearage buckets for that customer, 0 to 30, 31 to 60, 61 to 90, and so forth. We wouldn't need, or suppliers wouldn't need that information if we have the eligibility requirements. So that's a cost that one of the discussions we had in the working group actually was that it's more costly to the utilities to add that pre-enrollment information as opposed to the eligibility requirement. But so if there's the eligibility requirement, the short answer is we don't need that arrearage information in the pre-enrollment phase, so we wouldn't have to request it.
So I understand that, and thank you for that. I guess my question is more along the lines of, how would you know a customer is eligible to enroll them if you don't have their payment history?
Under the eligibility requirement, the supplier would not know until they submitted the enrollment EDI or XML transaction, and then they would receive back an electronic transaction rejecting the enrollment, and it would have a reason code that's going to be attached to it that they'll figure out in the EDI and XML working groups that will tell the supplier the enrollment's been rejected and it's because they're outside of the 30 days or they're on a payment arrangement plan. And then it's up to the supplier to go back to the customer and tell them what happened.
So you would accept all the information from the customer, and I guess the customer is told that you may be enrolled or something of that sort until they get a confirmation from supplier or utility?
Right, and two answers to that. First, that's no different than how it works today, right? If I get the customer's information and I have something flawed in that information, or for whatever reason the utility rejects the enrollment, I get that rejection back. I don't know if it always has a reason code attached to it, but it may. And then I go back to the customer and say, the enrollment was rejected because I may have spelled your name wrong, or whatever, or maybe I have an inverted account or customer choice ID number, something along those lines. So that gets worked out today, and I would imagine it would follow the same path under SCB with these eligibility requirements. And the second thing is that there's also going to be a credit screen in all likelihood. Suppliers, with SCB, with the financial risk that they'll be accepting, I would, generally speaking, suppliers will also credit screen the customers to ensure that hopefully they'll be on-time payers going forward, and to see what kind of credit history they have, obviously. Okay. So I hope that answers your question.
That does. Thank you, Mr. Green. And so, Mr. Trout, in your response earlier, you noted that sometime in the future we could pursue this concept again if there's after we've had an opportunity to have some experience and learn a little more behind it, how everything operates. Do you have some thoughts on what the utilities or suppliers would be learning? I mean, what is it that you think we don't have as information now that after working with SCB for a little while, it would make it eligible to what most likely will be low-income customers, for example?
Well, from a utility perspective, Commissioner, I think one of the most important data points that we would derive from operation of the program would be, does the program, even if we screen out payment troubled customers at the outset, does the program materially increase service terminations? Does it materially increase uncollectibles that have to be borne by other customers who are not on SCB? If it does, that would call for adjustments to the program in one direction. If, on the other hand, the program, once it's launched and is operating, functions smoothly and as all the parties hope that it would, and you do not have material increases in service terminations and in utility uncollectibles that could be traced back to customers going on SCB and then getting bounced back to utilities, then it is possible that adjustments could be made in the other in the other direction. That's not the only consideration, but that's the one from a utility perspective that comes most immediately to mind to me.
Okay, so we're thinking of this more as less as a challenge or difficulty with figuring out how to manage the enrollment process for payment challenge customers now from a regulatory regulatory construct, but more about kind of just getting things started for now.
I'm sorry, Commissioner. No, I was thinking about in the future, how would we determine whether to alter the eligibility requirements, and that was what I addressed. The reason now, the reasons now for not doing this are at least as much about just sheer workability. There's a lot of steps and boxes in the staff's chart, their flow chart, that get simplified or eliminated. And there are lots of things that the suppliers and the utilities working together, meeting weekly for more than a year, just haven't been able to figure out how to make work with the groups of customers that we are all, except for staff, proposing to exclude from the initial launch. So yes, there's still the concern. There's still the concern about impact on customer terminations, impact on costs imposed on other customers. That is going to be a constant with respect to this issue. But at least as important right now is just the sheer volume of the technical issues that we just can't make work despite all our efforts. Mr. Green has thrown all of his and his clients' best efforts into it. The utilities have done the same. We've had thoughts from staff. We've had thoughts from the Office of People's Counsel, and we just can't see it. We can't see how to make it work, at least not well. So why potentially poison the program at the outset by building something into it that we know in advance we have very serious concerns about working?
All right. Thank you, Mr. Chairman. I appreciate the answer. That's all I have, Mr. Chairman. Thank you.
Mr. Chairman.
Sure, Donald.
Thank you, Mr. Chairman. Ms. Garofalo, this may be repetitive to some degree, but I want to make sure I understand staff's position a little bit better as to why you have this position. Would it be fair to say that preventing customers from participating in SCB is contrary to statute, as you're kind of where you're at on this, your position? You think it's contrary to statute, or does staff think it's contrary to statute?
Well, I guess the statute is silent on this, but it's not as if this is a statute that was passed yesterday. So there is some history behind this, and the Commission has consistently said that the billing information is the billing method is the choice of the customer. We've said that in several orders. The other thing I think that concerns us is that while we think the pre-enrollment information would resolve this problem, we also are concerned that the electronic transactions will be the method by which customers are informed about whether they've been accepted or rejected. So I think it could be even that they would have signed a contract, the contract would be put through, and then it would be rejected. And I guess after that, the supplier will or will not. I mean, we have a lot of good suppliers here today. Everyone's not a saint who's involved in the supply industry. And so the supplier may or may not inform the customer in a no manner that's reasonable, that can be reasonably understood, that they have been rejected, and the reason why for that. So we really had, so while mainly we were trying to follow the statute and your orders, there is this other problem that's involved in that we thought would be fair.
Fair enough, but you're going pretty far afield from what I intended to ask you. So let me kind of get back on track. Do you think, very specifically, that if we were to adopt the position of all the other parties in this proceeding, that we would be violating statute?
I think that that's the commission's choice.
Well, I'm asking you as a staff attorney.
No, as a staff attorney, as a staff attorney, looking at the statute and looking at previous orders, we felt this was the recommendation we needed to make, but we also think that you could make a different decision.
Okay, that's really all I'm trying to make sure, that we're not running afoul of statute, because to me, statute trumps COMAR, and I heard the other arguments from Mr. Trout and others about COMAR, but I want to make sure there's not a statutory prohibition that would stop us from doing this, because that's very important to me because of my background. Okay, so that's really why I'm asking what I'm asking. And I hear you saying, no, there's no statutory prohibition from us adopting the other party's position. Is that right?
That's correct.
Okay, fair enough. Mr. Chairman, I have another question on eligibility, but it's not this one. I am fine with the majority position here, I think. And I just wanted to get on the record that, you know, we're not going against the statutory enactment. So.
Commissioner, I do agree with Ms. Garofalo that the statute is silent with respect to this issue. And I think all the parties and the commissioners have generally agreed that this is an issue that will be revisited at a future date, but not at the moment.
So, right. Mr. Chairman, is this the appropriate time to ask my other eligibility question?
I don't know what it is, but let's see what it is, and perhaps staff could tell us if they're going to address it later on today.
Okay. So can staff tell me if there's anything in the proposed regulations that deal with supplier eligibility? Because early on, we had a lot of discussion about supplier eligibility to participate in supplier consolidated billing, and I don't seem to see anything that addresses that issue.
Hello. Oh, go ahead. I'm sorry. I think, are you referring to if we would restrict a supplier from providing supplier consolidated billing services?
That's right. Early on in the discussions about supplier consolidated billing, there were discussions of certain size companies, treating everybody fairly, not discriminating. Here's why I'm getting to this, because I don't think there's anything here. At least that's what I've been told, but we're just going to take it on a case-by-case basis. But I'm trying to figure out how we draw the line. COMAR regulations and rulemakings are intended to kind of memorialize how we're going to treat everybody fairly, right? This is the basic principle of rulemaking. And if we're going to exclude some people, we're going to take them on a case-by-case basis for being a eligible supplier to do consolidated billing. How do I know where the line is? How do I know that I'm treating everybody fairly if there's nothing in the regs? In other words, how do I deny company A and approve company B? Because company A has 15 complaints and company C has 7 complaints. And how do I know where that is if we don't discuss supplier eligibility?
Okay, so we do not make any specific so there are no COMARs that directly restrict a supplier's being able to participate in supplier consolidated billing. The proposed licensing regulations lay out, here are some additional informations and affidavits we're going to request of you. We're also requesting a higher bond because we're going to be expecting higher customer behavior from you. There's also call center metrics that will be required of suppliers, which are in the COMARs in 2053-08 and 59-08, which is a new section. which would basically say we're going to require you to have specific call center metrics, and you will need to report those to us every so often. We were also going to require suppliers to track track, but they were not going to be mandatory reporting. They would only report if requested information regarding complaints and other customer service. But in terms of at the offset, there are no size thresholds, and there are no complaint thresholds that we have put in the COMAR at this time.
Thank you for that. I appreciate that. Did the work group consider or discuss at all whether or not a kind of a broad COMAR that says, the commission may consider many factors when either granting or denying, including, and then just listing some general categories, and then saying, and the commission shall consider in totality whether or not granting or removing a license, SCB authorization, may be in the public interest, and just put it under a general public interest standard. Everybody's treated the same.
We put into the proposed COMARs, so we didn't talk about having a general statement of here's various issues that we will look at for you. But we did put in a catch-all in the supplier licensing regulation. So I'm going to open up 2051 to read it to you to make sure you understand where I'm going with it, which basically states the supplier that the commission, let me just find it and give you the exact language. Okay, so within the proposed, I'm using 2051 of the proposed regulation section. What is this? Chapter 2, subchapter 2, part E. We put in 5 additional certifications requirements that the supplier will be required to go through. And then I would say the 5th one, I should say, so there were 4. And then the 5th one that we added is such additional information as the commission may require. And so that might not be getting towards here's what we're going to examine, but it does give you the ability to, or we would have basically saying we might want more than this when we're looking through your application. And then within our application materials, that's where we would have a lot more of the specific information that we're requesting them to provide. But once again, it's not really stating if you don't meet a threshold, you're not in. Which maybe that is what you were looking for.
Yeah, I'm just trying to contrast it to the previous discussion on customer eligibility, which staff's position was all customers are eligible, and staff's position here is all suppliers are eligible, I think. Is that right?
It's not every supplier is eligible because we're going to review their complaint histories, and we're going to be asking them to be able to uphold they're going to need to be able to undergo higher technical specifications. But if they can meet all those, we would not preclude them from joining. We would not have a preclusion on them being able to join SCB. I guess I view them slightly differently because a supplier is going to have an obligation to serve these customers. And so we're going to expect certain capabilities out of our suppliers to do that, and in this case, we're going to have higher expectations of them than we would of the utility consolidated billers because they are providing the customer the bill. But on the flip side, for our customer eligibility discussion that we just had, we were of the opinion that that the bill method is part of the customer's competitive choice, and it's part of the supplier's business choice to decide if they want to take those customers on or not, and that it was unnecessary to have limits at this time to that in the process. So I guess I'm having a hard time putting the two together because I view them as, I guess, 2 separate risk tracks, but not, but yeah, sorry, yes.
Yeah, I appreciate that. They are different, but kind of tangentially related, I guess. But I'm trying to figure out in my mind how this commission or future commissions would determine whether or not any given supplier meets this unspecified kind of nebulous eligibility. We're going to hold you to a higher standard and do it in a way that treats everybody the same if it's unspecified. I'm having a hard time figuring that out.
Okay, and I will take that back as well. And Michael Zhang he'll be helping lead the licensing on Wednesday, is when we're planning on discussing the licensing, and we can try and give you more certainty there, or if there is less certainty, I will also let you know then as well.
Fair enough. Thanks for the indulgence. Thank you, Mr. Chairman. I appreciate it.
This time, Mr. Baker, I believe we're in a position to move to your next item on the agenda.
Mr. Chairman, can I just ask one question? I was interested in Commissioner O'Donnell's question about supplier eligibility. Do I understand we're going to be bringing this specific section up later? Because I was interested in hearing from OPC. I think that they are offering some proposed language if we wanted to, I guess, bolster any of these supplier eligibility.
Yes.
Is that something planned for later?
According to our agenda for Wednesday, that general topic is on our schedule for Wednesday.
Okay, great. I just wanted to be sure of that, so we didn't miss the opportunity. Can I ask Ms. Garofalo one question before we move on to? She said something that struck my interest, and that was about the possibility of the reasoning and there be confusion from a customer why they were being rejected. Should we be very explicit in this rulemaking what I guess okay reasoning is for rejection, just to make sure that there isn't I guess illegal biases or other types of illegal discrimination that could be contemplated?
Well, I think the suppliers and the utilities are proposing something that's very definite. Two things: the age and size of arrears, and whether or not the customer's on a payment plan. So, and I understand that to mean currently, and if that's not clear, I guess we could clear that up in the regulations. So I don't think that's necessary, although you could certainly do that. What I was referring to was the fact that they would be actually in the chain. An agreement would go into the EDI transactions, and then if they're rejected, I'm not sure how it would be up to the supplier to tell them that. I'm not sure exactly how that would happen.
Okay, I appreciate that answer. I was just concerned when you raised this idea that a customer could be confused why they were being rejected. So if you think that the language currently proposed is okay, then I appreciate that answer. Thank you. Thank you, Mr. Chairman.
Thank you. I said we were going to take a break around 11:30, but let us take a brief recess now before we get involved into the next issue. So we'll be in recess until 11:25 a.m. We are back on the record. And we'll move to the next item on the agenda.
Hello, Commissioners. So the next topic on the agenda that we would like to review is there are two competing purchase of receivables proposals now in front of the Commission. And since where we go with these two proposals has significant implications for the remainder of the, I would argue, majority of the regulations that we have in front of us this week, I wanted to tackle it early because it would have implications for a number of the customer protections and other processes that were developed over the course of the work group proceeding. I would also note, though, that this issue is this and the other issues that we plan to talk about today are also very interrelated. So, of the two competing proposals, and there are two competing proposals in front of the Commission. The proposed COMARs and implement a purchase of receivables process whereby the supplier will purchase 100% of the utilities receivable at no discount rate every 23 or for non-residential, or every 28 days for residential customers. The supplier will post payments to the customer's charges following a payment posting system approved by the Commission, and we will be discussing those various proposals later this afternoon. The structure of payment posting is not, and those issues would be the treatment of supplier and utility charges, bundled charges, and a gas and electric charges on the bill. They will follow this payment posting system until the customer is no longer a customer of the suppliers. And once the customer is no longer receiving service from the supplier, the customer's utility arrears will be sold back to the utility. There are two limits proposed to the supplier being able to return arrears to the utility. First, if an arrears is past a certain age, it cannot be returned to the utility. There is general agreement on this point, though not on the exact age. Second, a supplier cannot return arrears if they still provide commodity service to the customer. For example, if a supplier is no longer providing the bill, but the customer is taking supply service from the supplier under UCB. There is disagreement about this second limit, where some utilities believe the customer must be on SOS or sales service before returning the arrears, while some suppliers believe they can return that arrearage once the supplier stops providing the bill. Before a supplier returns arrears to the utility, the supplier will be required to provide the customer 2 collection notices. Once the utility receives the arrears, the utility will bill the customer for charges and can pursue service termination against the customer if the charges meet the service termination requirements, as we discussed earlier today. And then also to be aware of, the utility will bill these charges and will not transfer these charges to another supplier if the customer chooses another SCB provider. Though since we are likely to be seeing an eligibility requirement, this second issue will likely be mitigated considerably. Alternatively, the joint Exelon utilities, towards the end of the work group process, proposed an alternative POR approach. The joint Exelon utilities proposal assumes the supplier will purchase a utilities distribution receivables at a discount rate. In the first year, the discount rate will be based on utilities uncollectibles experience, but after the first year, it will be unique to each supplier who will have their own discount rate based off their own uncollectible experience. This means suppliers will not purchase 100% of the utilities receivables in SCB. As a trade-off, though, a supplier cannot return a customer's unpaid utility receivables once the customer was no longer the supplier's. The joint Exelon utilities argue that their proposal solves issues related to partial payments, tracking and managing of customers' arrearages, and how to address arrearages at time of switch. So, in our reply, staff believes that the proposed purchase of receivables process and the proposed regulations is still the most appropriate solution, as we provided on pages 29 and 30 of our reply comments. We still believe the payment posting structure will be contentious, and we will need decisions regarding the treatment of bundled charges, and gas and electric charges. Additionally, we would still need most of the reporting, though maybe it would be slightly different for a supplier under the Joint Exelon Utilities discount rate for their credit and collections and uncollectibles approaches and customers' arrearages, because all this information would be needed to calculate the customer's discount rate. Therefore, the burden would be shifted from the utilities to the commission, and this might be an administratively burdensome task since the discount rate is needed for each supplier in each service territory. Likely, the process will still require some limits to the amount of arrearages a utility may purchase to protect ratepayers from suppliers' collection habits past a certain point. Staff agrees that there would not need to be a transfer of arrears back to the utility for billing under the Joint Exelon Utilities proposal, though. Staff notes the commission order implementing SCB envisioned a supplier being able to return distribution debt to protect suppliers from non-paying customers after reasonable collection efforts. The proposed regulations implement this requirement from the order, unlike the Joint Exelon Utilities proposal. Finally, since the Joint Exelon Utility proposal occurred late within the workgroup process, and since it is a fundamental shift in the paradigm designed, staff believes additional time would be necessary to modify the proposed regulations to implement the Joint Exelon Utilities proposal. Therefore, the Commission should continue to support the proposed POR process, and we are available for questions. Thank you.
Thank you, Mr. Baker. Would other parties care to address this issue?
Good morning, Mr. Chairman and Commissioners. Can you hear me okay?
We're having a little difficulty. If you could turn off your video, it might improve.
Is that better, Your Honor?
So far it is, yes.
Okay, I apologize about that. Thank you very much. First of all, when I entered my appearance, we neglected to mention that we also have several subject matter experts on the line to answer questions from the commissioners, one of whom is Mr. Mike McShane, who is our subject matter expert on the Joint Utilities Purchase of Receivables proposal. As the commissioners are aware, the payment posting issue is one of the biggest non-consensus issues in this proceeding. And the purpose of the Joint Utilities proposal was to offer an alternative to essentially make the utilities more agnostic as to how the payment posting issue is resolved. As staff just indicated, the way that it would work under the Joint Utilities proposal is that suppliers would continue to purchase the distribution receivables from the utilities, but it would be done at a discount rate. This is currently what is done under utility consolidated billing. And in that matter, what the joint utilities are proposing is consistent with the commission's finding in its order that the SCB, the suppliers should provide purchase of receivables to the utility on substantially the same terms as provided under utility consolidated billing. Moreover, we believe that the implementation associated with the joint utilities proposal would be considerably easier because the tracking of SCB customer uncollectibles to be reported to the utilities would no longer be necessary. Moreover, suppliers would not need to be subject to any arrearage reporting requirements to the utilities as they would under the current tariff. And in response to the comments that staff just provided, it is true that suppliers would be reporting material to the commission in order to set their discount rates each year. But that currently happens right now under utility consolidated billing. So there is already a process in place. And I would also note that it appears that there are not very many suppliers who, at least at the outset, are going to be implementing supplier consolidated billing. An example is that the petitioners themselves are only 6 suppliers. So we do not believe that any administrative burden on the commission or its staff would be unreasonable or unmanageable for that matter. We do acknowledge that this proposal came late in the process, and as we stated in our comments, we do stand ready to work with any and all parties to work out any details that do need to be worked out. And we're available if the commissioners have any questions.
And Mr. Seegers, I understand Office of People's Counsel and Potomac Edison are aligned with your proposal. Is that right?
I know that Potomac Edison is. I believe the Office of People's Counsel in their reply comments, they did not, that they do not favor it. Will Mr. Auslander speak to that, Your Honor?
Yes, Mr. Auslander.
I'm sorry, I didn't pick up what the last sentence he said.
No, Mr. Seegers, that was your words.
I was just saying that I do not believe the Office of People's Counsel can comments, but I will defer to Mr. Auslander on that.
This is Jake Auslander with the Maryland Office of People's Counsel. Mr. Seegers is correct. OPC did review the proposal, but did not believe that that there was sufficient extra benefits that would be provided by that approach. In fact, we thought that it would add a lot more complexity, and we didn't really see what extra value was being provided. So we actually prefer to stick with the proposal as filed by staff. There are challenges in that proposal as well, but we believe that proposal was more fully vetted, and we're more comfortable with taking that approach than the one that Matt Seegers just referred to.
Okay. Thank you. Now let's hear from the petitioners, which I recognize they have their standalone proposal, giving a preference to supply commodity arrearages first, but that it appears that they're in some agreement or they do not oppose staff's attempt at compromise. Mr. Green?
Well, insofar as the insofar as the joint utilities POR proposal is concerned, we do not support that. We think that it was introduced so late in the day, and as Mr. Auslander said, it has not been fully vetted. It literally was shared with the entire group in the last working group session during about the last 10 or 15 minutes. And we never saw anything in writing until after that. We appreciate the work that went into it and the attempt to try to address various issues, but our takeaway at the end of the day was that the counter proposal or counter POR proposal actually creates more problems than it solves. And it does introduce more complexities, and we think potentially more costly to distribution ratepayers at the end of the day than the structure that is in the proposed rules. And I'll just tick down a couple of our concerns with the joint utilities proposal. Is that in calculating the discount rate that suppliers would pay up front, it treats suppliers the same way as utilities. They're not the same, obviously. Utilities can terminate. They have that stick when they go to collect. We don't have that. So it would be unreasonable to conclude that our collection percentages are going to be what the utilities are. We only have to look at the last 8 months, right, when the utilities couldn't terminate to see what happened with arrearages and uncollectibles. We also have a concern because the proposal doesn't seem to consider what happens if you have widely different uncollectible percentages or amounts by supplier, and you have big differences in discount rates. Or is the utility or staff or the commission or OPC going to go behind the calculation that gets submitted every year from the supplier and determine, is that really your uncollectible rate? Is that really, is your math really correct? What exactly were you doing to collect these things, to collect these amounts? Is the commission going to get into the reasonableness of the supplier's collections practices and whether it's robust enough to support the filing? We would hope not. And we think in doing all of that, and look, we don't know how many suppliers are going to participate in this program, but we do know that if we get the rules right, we think there'll be a considerable amount over time who will be participating. And I would add that while my clients are 6 companies under their respective corporate umbrellas, I count over 15 respective retail suppliers, many of which are licensed and active in Maryland. So we're talking about an administrative burden for staff to go through these filings on an annual basis. The other problems we see is that under the proposal, a non-paying customer, the supplier's recourse is to drop that customer to SOS. And we own the distribution, and under the proposal, we would own the distribution receivable, right? And the supply receivable. The supplier goes back to SOS with a clean slate. No arrearages, right? So we have to go collect that. And so our discount rate or our uncollectibles are going to be higher. In the proposed structure, the customer goes back to SOS and then there's a repurchase and the utility goes to collect with the full power of terminating service, right? So, and then whatever is uncollected, I would assume gets collected somehow by the utility. So it's very likely under the joint utilities POR proposal that at the end of the day, the uncollectible amount will be higher because we don't have because the discount rates for paying the discount rates that will be out there could be 10%. We don't know, but we can't rely on the threat of termination to collect. And yet, in other words, think of it this way. If a discount rate for a supplier is 5% under the joint utilities proposal, they are going to pay next year 95 cents on the dollar for all the distribution receivables that they buy. Somehow, the utility is going to have to recover that other nickel, right? But if the utility had that receivable and could go collect, it could be lower than 5%. So we think that there's a very good possibility that the joint utilities proposal could lead to higher costs for shopping and non-shopping customers. And then finally, we think that it does not resolve open issues. There's still payment posting to deal with, and there's still the issue of bundled charges that we'll talk about this afternoon. But you're still going to have to account for that as the supplier under the joint utilities proposals. So I just wanted to make sure that the record properly reflected our opposition. We have commented on this both in our initial comments and in our reply comments, but I wanted to make sure that if there's any questions that we're happy to take them. And I hope that's responsive in what you're asking me, Mr. Chairman. If it wasn't, I will try again.
It was entirely responsive.
Okay.
Perhaps now you can move towards your perspective on staff's position.
There are some, we do support in general, we support the structure that has been filed. We appreciate, look, when we filed the petition, we asked for, the ability to initiate the disconnect process. We didn't get that. We respect that decision. We appreciate, and I don't say this pejoratively, the consolation prize that the commission came up with, which was that when we drop customers back to SOS, we have the right after a reasonable collection effort to seek repurchase of those utility charges. We've spent a year fashioning regulations around that very issue, and it is complex, it is unique, but we feel like on the whole that the regulations are fair, and we've done our best to submit as petitioners to be flexible and to present balanced regulations that take everyone's interest into considerations from a customer protection standpoint and from a financial risk standpoint. There are, however, issues that we just couldn't agree on, and perhaps the biggest two are the payment posting system and the treatment of bundled charges. And we filed substantial comments on those. We'll talk about those this afternoon. There are some other, I don't want to call them minor issues, but I'll just say not as important issues that Mr. Baker mentioned, a few of them. We'll get to those later this week. But on the whole, we think it's a very fair and balanced set of rules.
Are there other interested stakeholders that wish to speak before the commissioners ask questions? Okay, Do commissioners have questions of the utilities, the suppliers, or staff? Commissioner Richard?
Yeah, actually, I was going to find out if DECA was going to speak up, because aren't they a supplier that does favor the purchase of receivable with a discount?
Mr. Sergeyev, would you like to respond to the commissioner's question? Sir, Mr. Sergeyev, you could hear us, but we can't hear you.
Can you hear now?
Yes, we can.
Okay. Michael Sergeyev, DEC Energy. We're a supplier and we're supporting joint utilities proposal because one of the reasons we are going, what we just addressed before with the eligibility, is that complication that could arise in the beginning of the program. And we decided that just the fact that we can get this program off the ground is already important. We think that operational issues that would result in not implementing joint utilities proposal is really, really complicated. So I think it is easier for the same amount of dollars going, if the credit risk is the same, we would say that joint utilities proposal is much simpler to implement. And the amount of dollars that utilities will have to somehow eat, I think is the same, because since we have eligibility requirement, we don't think more people will start gaming the system and actually not pay to the supplier, whereas they would pay to the utility. So we think the proposal that joint utility put forward is reasonable, has the same dollar amount, is much easier to implement.
Commissioner Richard, did you have any follow-up?
No, so I heard you correctly that you do support the joint utilities proposal. And then maybe that, Mr. Green, I'm just trying to fully understand how you're looking at this with the discount. You did suggest that there would be difficulties in collection. If the discount is set appropriately, won't that make the suppliers whole?
Right. The problem is setting it correctly with any degree of certainty or reasonableness. And you're going to have different suppliers using different collections practices and uncollectibles for various reasons, right? Because the practices aren't robust enough, or maybe there's just bad luck, right? There's a bankruptcy filing or something like that, or there's a pandemic. Our problem is that we haven't seen anything in the utilities proposal that leads us to believe that you can get the discount rate correct. And is this a road that the commission and the stakeholders, not the utilities, really want to go down, where the suppliers participating in the program are producing their books every year, essentially as some sort of audit process to determine whether the uncollectibles are what we say they are? And then how do you get it right? And how do you assess for the fact that we can't terminate, but they can? So why should we have the same formula with the same inputs? So there were so many problems and complexities with the proposal that we felt like actually the certainty of the proposed rules and the structure we've been talking about for the last year was actually easier and to not just to understand, but perhaps even it may not be easier operationally to implement, but it was definitely easier and encouraged more suppliers to come to participate in the program.
Okay. So a big issue, if I'm hearing you correctly, is it's a very new proposal that hasn't had a chance to be vetted. So is that a major concern, or is it some of the other things you itemized, you listed?
Well, that is one concern. I mean, it may be that, I mean, I don't know that if future vetting can figure this out, right? I mean, I don't know, but I know that I do not disagree with staff's assessment in its reply comments that we would probably need at least another 3 months to rewrite these regulations and bring them to speed. I don't know if more vetting will fix this because, quite frankly, I'm not hopeful that it will, because there's so many disagreements and so many problems with treating a supplier uncollectibles on par with a utility uncollectible.
Do you think these systems could operate side by side? In other words, could offer the suppliers the option whether they were to sell back the debt or whether they wanted to have a discount rate?
You know, there have been talk in the working group, and I can't speak to that because I'm not a systems expert, but there was talk in the working group about other issues where what if we created this other way to do things and suppliers could choose? And really the resounding feedback from the utilities and the suppliers was that they'd have to create two systems, right? And that would dramatically increase the costs, not just for the utilities, but for suppliers as well. And so I am sure in the world of technology, anything is possible, right? You can do anything, but at what cost and at what bang for your buck? And we've not talked about that at all with respect to this proposal.
Okay, well, we've heard that at least one supplier is interested in going the joint utilities route, that is, have the discount. So does that change your thinking at all? The fact that there may be suppliers out there that would like to have the option of the discounted for.
I mean, I have my 6 clients that, like I said, represent more than 15 individual suppliers. Oppose it. I can't speculate or speak for anyone else.
Okay. All right. The last is, I mean, does the fact that if we go in the direction of limiting customer eligibility, in other words, have the customer eligibility, hopefully that already screens out a lot of the concerns. I mean, as the chairman said at the beginning, a lot of the time we're spending on this is about about non-payment. So if the suppliers already have screened out a lot of those potential non-payers, I mean, is that in itself solving a lot of the supplier problems?
No. I mean, you still have this massive problem of, you still have other very important issues that have to be dealt with in terms of partial payments and in terms of bundled charges, and also here to do a discount rate annually based on what is my company's uncollectibles during the prior year or whatever the time period may be. 1 year it could be 10%, 1 year it could be 20%. I don't, it could be 5%. I don't know what the answer is going to be, but it could be a big number. And I just think that the ability to do collections and how you do it is a competitive function. And if some suppliers are going to be really robust about it, or they're going to be extremely careful about how credit screening and who they enroll, a customer could be eligible for SCB under the eligibility requirements, but not get by the credit screen. So, because they may have prior history problem, prior credit problems. So, our view, in addition to the complexities of this proposal and the insufficiencies of it, is that collections are a competitive function, and if you do it really well, and however much you want to invest in collections, that's a supplier by supplier decision, and it shouldn't be reflected in some sort of formulaic discount rate on a going forward basis, which could potentially come back and result in higher costs to all customers.
Okay. Thank you, Mr. Chairman.
Mr. Baker, I have a question for you. I do view staff's position as a compromise position with the petitioners, recognizing that the joint utilities proposal came in rather late, so maybe it's not a compromise as far as they're concerned. Mr. Green, if we could put you on mute. In the reply comments that were filed in December by joint utilities, they had some criticisms of the pro rata payment posting method that staff put forward. And they were concerned that this method would result in some SCB customers being returned to SOS with higher distribution arrearages than they would have under a method where utility arrearages were paid first. And that does make sense. So my question is, are we putting SCB customers potentially in a worse off situation by supporting staff's compromise approach?
I don't. So I guess two things. One, we are planning on discussing the idea, like the structure of the payment posting after this discussion, where we're kind of discussing how you would get around to dealing with customers on collectibles. So just to bifurcate the two. But if I was to look just simply at the payment posting structure and thinking about, do I pay utility arrearages before supplier arrearages, or do I pay them at the same time? I've been thinking about this issue, and I think it depends on whose perspective you're looking at it from. So and this is also what led to a number of the, this is one of the reasons that led to the limit on arrearage repurchase by the utility that we have in the proposed COMARs. And so, which is basically, at a certain point, we do need to be cognizant of that a supplier, collection of habits could increase utility uncollectibles and therefore increase distribution rates for ratepayers if we're not careful. And I think that was something that in your order, you wanted to make sure that utilities were not unduly burdened by the purchase of receivables process. And so, but I guess so, looking at it from two perspectives. If I'm looking at it from the customer's perspective who is on SCB, I don't think that they are really, I question if they actually are, it's hard for me to say, but I question if they are actually worse off, if maybe they could be off maybe a little better under SCB, because the customers, when the customers return to the utility under the proposal that's with the commission, there's no supply arrearages coming back with them. Unlike today under utility consolidated billing, sales service, SOS, that customer's entire arrearage has to be collected by the utility. So now the utility is only having to go after distribution charges. They're not having to go after any of the supply commodity. They don't have to go after any commodity charges. On the flip side, and this is the part where this is what causes me unsurety, is that and under the proposed rules, it is possible a customer will come back to the utility with slightly more distribution arrearages because, and this is distribution arrearages, but not the total arrearages, because because under the limit, that customer could be coming back in month 4 or 5 without, they could be coming back in month 4 or 5 to the utility when under the COMAR, a utility can start pursuing service termination against the customer at month 3. And so that's the balance here that we're trying to strike. And so I view the proposed purchase of receivables payment posting structure as a compromise that tries to minimize distribution arrears, but also recognizes that suppliers have that suppliers do bear more risk under the SCB market than they might bear under the UCB market. And so I view that as the fair and equitable standard that was also put in the commission's order when discussing payment posting.
Thank you, Mr. Baker. Commissioner Herman?
My turn? Okay. So, Mr. Baker, if you could help me understand this repurchase. I'm still having a hard time, and I'm looking at your chart or your process flow on page 4, I think is the right one. But I'm confused as to how long all of this takes. how soon does the utility repurchase it? And when does the utility send the bill associated with the repurchase?
So I'm going to direct you to another part of that document. Give me 1 minute. Okay, so in the PDF, this would be starting on page 27, or I guess it's labeled 26 in the document. But if you're going off the PDF numbers, 27. So this was a generic attempt at basically trying to outline, we have a customer who's not paying the supplier. I don't know if it's helpful for this to be shown on the screen for other parties, but so this is 27, this is page 26, 27 of the business process flows. And so one more down on the screen. So when a customer is not paying the supplier, so basically if I walk through the life of the customer with the supplier at this point, they receive their bill. We're assuming it's due in 20 days for a residential customer following normal procedures. And then if they miss that payment, and we're trying to do kind of a worst case analysis here, is the supplier will then send that customer a drop for non-payment notice 1 day after that customer fails to pay. At that point, the clock starts ticking. This was, now I guess there is a correction I need to make here, is originally when this was designed, we were assuming the drop for non-payment notice was 15 days, not 5 days. So this chart now is a little out of date. But assuming that the supplier might have worked with that customer for a couple of days before sending the drop for non-payment, the supplier will get past that first bill and into a second bill with the customer, at which point they would drop that customer. But that customer still has to pay that bill to the supplier. And once again, if they don't pay that bill, it's just going to roll into that final bill that's going to come to them, which is shown in the third box. And at that point, in that third box, that's the final bill sent. And so they get that second collect, and then we'll go through that process. If they're going to get 2 collection notices, and on April 1st, they would be dropped for non-payment. And so from the time of non-payment to the drop for non-payment, whereby the utility can start billing that customer, is about 88 days from the invoice date, and 92 days. So that's the overall structure. If I need to go back on any of this, please let me know. I'm sorry if this was.
Okay, so it takes 90 days before the customer gets dropped and back to the utility under the proposal. And then when does the utility repurchase that receivable? And when does the utility send a bill for that receivable? And my third question, sorry about that, is how much is the utility repurchasing? Is it the whole amount back to January 6th? Or is it some subset of that?
Right. Okay, so the customer is returned to the utility within about 15 days. So your first question, the customer is going to be returned to the utility much sooner than the arrearage is going to be returned to the utility. So during that time period, the customer will be getting billed by the utility while also receiving a final bill from the supplier. But that bill from the utility will not be carrying the customer's arrearage just yet. That arrearage will follow, based off of this chart, about a month and a half later. And so
a month and a half after the 15 days?
Right, so after February 11th, 2020.
So that would be then about a month and a half,
Right, and
then that's when the utility would purchase the receivable back to the very beginning.
correct, and that receivable would go all the way back to January 1st, January 1st, or not January 1st, sorry, January 6th, which is that very first box in the far left corner.
Okay, so the utility buys back its full arrearage.
Correct.
And then there's multiple bills going back and forth
Right.
in that 45 to 90 day period between the utility and the supplier, which I guess is inevitable and complicated, but inevitable. So then my question becomes, how do we as the commission know that the supplier did not get paid? You know, what kind of assurances or auditing are we going to do? Because, I mean, in theory, we don't know what the customer is paying. We're just, you know, we have all sorts of audit authority over utilities and we can go in and look at them. But how do we know that the supplier, and no offense, Mr. Green, and to your clients, but how do we know? What kind of checks do we have on that process?
Right. And so, so the utility, there's going to be a little bit of good faith here, but because of what's going to happen is over the time while the customer is with the supplier, the supplier is going to be sending a monthly or every 2 weeks an arrearage report to the utility that would include things such as the outstanding arrearage the customer has with the utility. And also there's discussion of including things such as the customer's payment history within that. But also within the proposed regulations is if a supplier submits an arrearage for repurchase, they need to have retained the information to prove that that this was the customer's payment history and this was the customer's and here's how we applied it following the prescribed payment posting system that is in COMAR. And so us or the utilities can request to look at that information. And if we disagree with what we're seeing, then there would be a challenge and that could come to the commission. But that would effectively be the audit process as it is set up today, which is the supplier is supposed to send their information that shows that the payment history and the application of the payment posting structure. And then they need to retain that. And if there's ever a question regarding the arrears resubmitted for purchase, then we go in and look at it. But the utility will also be informed over time of a customer's building arrearage because there's supposed to be a report every 2 weeks going back to the utility saying, here's what the arrearage looks like for your customers with us.
Okay, and so by being licensed by us, we would have the authority to go in and ostensibly to audit a supplier and say, you know, because you could end up with somebody saying, hey, I paid, you know, and a bunch of people saying, hey, I paid supplier X, and they're claiming I never paid them, and now the utility's coming after me and I don't want to pay twice, and so on and so forth. That we don't need any regulations that would include auditing authority that the supplier agrees, you know, to allow us to audit their books or anything like that to make sure that we don't end up in that situation.
I would need to ask, I guess, Ms. Garofalo, if you can speak to that. I think we have the COMAR that implies that we're going to do this. I'm going to pull up the exact site in our proposed COMAR regulations. But if you think we need some stronger language that states we certainly can do this, we can add that. It would be, if I'm going through the electric 2053 COMARs, it would be Chapter 5, Subchapter 13.
Yeah, we do have some auditing authority placed in these regulations. It probably would need to be edited to apply specifically to this function. We could do that. The language for regulatory purposes would not be a problem. The actual auditing itself, I would have to be honest, might be a little bit of a problem, but I guess that I would see this happening when a complaint is filed with the Consumer Affairs Division.
And the final part of that, right, Commissioner, is of 2053-05-13 is Section F, Subpart F. And part of that is we specifically state they will include in their records the customer's payment history, the appropriate application of the funds, and they will make those records available to both the commission and the utility upon request. But if you believe we need more specific auditing authority, we can certainly make these proposed COMARs stronger in that area.
Well, I just ask, staff to take a look and see whether you think we have sufficient authority for that, and come back to me later in the week. I just want to make sure, we're not, again, I'm not suggesting that all, I don't want anybody to think that I think that all suppliers are bad, but I mean, there is the opportunity here to get paid twice, and we want to make sure that doesn't happen. So I just want to make sure that we have the necessary tools to make sure that we're covered.
Okay, we will look into that. Thank you.
Thank you, Mr. Chairman. Mr. Green, I have a question for you.
Yes, sir.
So I would like for you to comment on what I think I heard as an assertion from Mr. Seegers that we already have a discount rate process. It already exists. It's well worn, it's well trotted, and the process already exists. Why is it problematic all of a sudden to create this discount rate for each supplier in the various territories?
There is a process that sorry, I got a lot of feedback there. There is a process that exists for establishing the discount rate in the UCB POR program. That is tailored to utilities who have the authority to disconnect for non-payment. Non-payment, I would add, of distribution and supply. To take that same formula and require suppliers to use the same inputs, which are uncollectibles and incremental costs and so forth, it's not a one-to-one relationship. And you're treating suppliers as if they have additional tools for collections that they don't have under this program. So you're going to see uncollectible rates that are likely going to be, I think we can all probably say they will be higher. And then it does not account for the fact that we can't terminate. So you're going to see it's the disc. If you look, I think probably if you could get the discount rate right, what they're saying, if you can resolve other issues that they don't that aren't resolved, maybe it would work. But I think that it's what we're not finding a way. And I would add, and maybe let me go back and correct something that I didn't mean to imply earlier, that we had never known that this existed until the last 10 minutes of the last working group meeting. So we had offline discussions with Exelon. So we had a lot of discussions about it internally on how to make it work, and have continued to have those discussions because they obviously put a lot of thought into it, and we wanted to give them the benefit of doing the same and properly and reasonably responding to them. We can't figure out how to do it in a way that makes sense financially and for proper consumer protections and the risk at the end of the day to all customers. We can't figure out how to make that work. And so, from when we looked at all of those issues, the starting point of their proposal treats suppliers and utilities equally. And if that's the starting point, that you can't get to a reasonable discount rate, and it creates all of these other complexities and problems and headaches that really can't be solved. And if they are, we can't, we don't know how to do it. And again, my clients send out millions of supplier consolidated bills in in other jurisdictions every month. And in some of those, maybe all, I don't remember, they do pay up front for the receivable, but there are different types of models, different payment posting systems. And like I said, this is a very unique structure that we're setting up here. So I apologize for the long-winded answer to your question, Commissioner, but we can't figure out how to get there with a discount rate up front that makes sense for everyone.
But it's not necessarily the complexity of figuring out what the discount rate is. It's because you don't have the stick to do the collections, right? It's not really the discount rate.
Right. And then once you figure out the discount rate, especially if there's going to be a different one for all suppliers, are you going to go behind that supplier's yellow curtain and audit their books to make sure that their collectibles are accurately calculated and that they're putting forth enough vigor in their collections efforts, whereas this other supplier over here might have much higher credit screening standards and much higher or much lower collection efforts.
I know you're not suggesting we should do that, Mr. Green.
Not at all. I think it's something you should run very far and very quickly away from.
I appreciate it. I appreciate the answer. I view purchase of receivables having been set up to compensate for your lack of ability to have the stick as you turn in the first place. And
that was
a major concession to the supplier community. A major concession.
Going back to the 2009, 2010 proceedings where the commission adopted POR for UCB, one of the supplier's main arguments was that it helped level the playing field because suppliers couldn't terminate, but the utilities could. And so we needed that level playing field to compete. You are correct.
All right. Thank you, Mr. Chairman. I appreciate it.
Linton.
Thank you, Mr. Chairman. I just have one question for the staff. Your regulations propose a number of different things, but one of them in particular is it allows the customer to choose the type of billing they would have, either consolidated billing, as we're talking about here, or UCB. So are you envisioning a scenario where a supplier could offer both consolidated billing and offer POR to customers at the same time?
Do you mean they offer both SDB and UCB simultaneously? Yes.
SDB and UCB, yes.
Yes, and in fact, yes, that is we had some of the issues that have been discussed. Maybe, I don't know if they've been discussed. They haven't been discussed yet, but some of our issues in this work report around that and the issue of the supplier. In fact, one of our concerns was the UCB suppliers, because they have a purchase of receivable discount rate in the UCB program, just have a fundamentally different risk profile than the SCB suppliers, who will have actual risk. They will have a risk associated with their supply related to their own receivables and not a socialized supply or uncollectible receivable. And so there are two different programs, and yes, we do. Our proposed regulations allow for them to do both. And so, but we do have concerns about how that plays out, which is actually why one of the issues that we raised in our written comments is not a COMAR thing, but was a request to consider looking at utility consolidated POR with the existence of SCB as well.
So I guess along those lines, if customers are, well, is there your regulations allow customers to choose between one or the other. Both statute gives customers the option to pick the billing that they want. And you've noted that in your regs in different places. For purposes of the utility buying back the receivable, do you think is that something that your proposed regulation would prohibit, or does it address it at all? A scenario where a customer could, or a supplier could simply switch a customer to POR as opposed to selling back the distribution costs.
Yes, in fact, this is one of the two limits that is under contention with the group. If you go in our proposed regulations under, it's actually it's in 2053-05-13 and it's under D. So there's two parts to this. This is the limitation, but then there's also a section where we discuss the issue of a supplier actively attempting to change a customer's bill method without going through their contract. And so in this, we've put a limit in place where we say a supplier may not sell the customer's arrearage back to the utility if the supplier is still providing commodity to the customer. The suppliers disagree. A number of suppliers disagree with that and believe that they should be able to return it once they no longer provide the bill. So if they can retain the customer under UCB, they believe they should be able to a couple of the utilities believe that regulation should basically be reworded to only allow the arrears to come back if the customer is on SOS or sales service. But our proposal is no, once the supplier should be able to return that debt to the utility once they no longer have a relationship with that customer. They shouldn't be penalized for the customer choosing to go to another supplier. But if a supplier knows they have a debt with this customer and they're a bad paying customer, or maybe not bad, but they're a customer behind on their payments, they shouldn't be able to, it just seems unfair that they would be able to say, here's a contract to retain them under that billing method while at the same time returning, or under a new billing method, but return their arrears to the utility. So basically shift their risk.
All right. So, and I'm assuming that this is a section, I'm looking at your section D now. I have been for a while, actually. So this is something that the suppliers are not, Mr. Green, is that fair to say that suppliers are not supportive of this section?
Yes, sir. We submitted red lines that would allow the SCB to supplier to change the billing method and there's a whole section, by the way, of how to change a billing method,
right?
That for consumer protection purposes. But it would allow the supplier to keep the customer and the customer to keep its supplier and transition over to UCB. And then for repurchasing purposes, the supplier would send the collection notices as required, the reasonable collection effort that the order required. But the main issue for us was that it puts the utility in the same financial position and potentially allows the customer to keep his or her supplier. And what I mean by the same financial position is that if the supplier drops the customer for non-payment back to SOS or sales service, then they go through the repurchase process and get repurchased for the distribution charges. Alternatively, they could go through the two-notice process and transition the customer to UCB, engage in reasonable collection efforts, and if that doesn't work, the utility repurchases. So the utility is in the same financial position either way. So there's, well, I hesitate with Mr. Baker's, well, with staff's, I should say, description that that's gaming the rules, because it may work out and should work out, hopefully, well for the customer because they get to keep the product that they signed up for. Now, there may be a payment problem, but they at least get to keep the product that way.
So the utility then under the proposal that the suppliers is suggesting here, the utility would purchase the distribution charges and the commodity under UCB, or would they just purchase the distribution?
Okay, so for SCB purposes on the repurchase, the only thing that the utility would purchase or repurchase is the distribution charge, and the supplier would have to engage in collection efforts to collect the supply charges. Once they're on UCB like any other customer.
And so the utility would then purchase the UCB receivables as they normally do today.
Yes, on a going forward basis, yes.
Going forward, okay. So any other add-on commodity charges would still be billed separately by the supplier?
Well, that's a
non-commodity charges.
right. So that's an issue for discussion that is, like I said, one of the issues with respect to bundled or packaged products that we're going to need to talk about this afternoon.
Right. Okay. All right. Thank you very much, Mr. Green. Thank you, Mr. Baker. And thank you, Mr. Chair.
Thank you, Commissioner. Commissioner O'Donnell, are you still with us? Okay, we may have lost Commissioner O'Donnell. It looks like his screen has frozen. Hopefully he'll come back with us shortly. So, Mr. Baker, at this point, you're seeking some guidance regarding payment posting from the commission. Is that right?
At this point, we were seeking guidance on the pursuit of the joint Exelon Utilities proposal versus the work group's proposal in front of you today. And I would note that, I mean, the issue at hand, as I look at it, as we try and work through the proposed regulations for the remainder of the week, is a number of issues that will come up on Thursday and Friday, and quite frankly, maybe even tomorrow, will be impacted by the decision of using the joint Exelon Utilities proposal versus the work group proposal in the proposed regulations, because a number of issues that are in this, or a number of customer protections and other developments, were designed around this idea that the arrearage could be returned to the utility, and therefore we had to have notifications in place so the customer understood this, and other protections in place to ensure some customers with the utility were not disadvantaged by that return. And so that would, I know that the commission is looking to take a number of issues under advisement, it sounds like, but this is one of those issues that I do think without guidance soon, we will be talking theoretically about the work group proposal, but you'll have the joint Exelon Utilities proposal hanging over your head in terms of the other issues in the case.
Thank you for making that clear, Mr. Baker, and I'm hopeful. I see Mr. Trout. Commissioner Linton, I just want to make sure you're still with us. Okay, commissioners are.
All right, Mr. Chairman, I am, yes.
Okay, thank you. Commissioner O'Donnell hopefully will rejoin us. I see that he departed. Mr. Trout.
Thank you, Mr. Chairman. I don't want to interrupt the flow of the discussion. I just wanted to make the point that from our perspective, Potomac Edison's perspective, purchase of receivables and payment posting are two separate issues, and the resolution of one issue does not necessarily resolve the outcome on the other issue, and they have occasionally over the course of the last hour gotten conflated. And it's true that there's a relationship between them because they have risk issues for customers and for suppliers that stretch across both issues. But I would hope that if the commission were about to take some position on the purchase of receivable options that are in front of it, that it would do so without prejudice to the discussion that's going to follow perhaps next, which is the discussion of payment posting.
Yes, Mr. Trout, that's a good point. I think over the past hour, the issue of POR and payment posting have overlapped and intertwined. And after this discussion, we will touch upon payment posting, bundle charges, and some other issues. So before us right now, we have the question of the work group proposal versus the joint Exelon Utilities proposal. In an attempt to level the playing field and make rulings that are, I think, equitable for both suppliers and the utilities, I believe both sides made some, both proposals had pros and cons to it. But for a number of reasons, to provide some guidance going forward, because I recognize day 1 may influence day 2, 3, and 4 of this proceeding. I am supportive of the work group proposal. Although I do hope that we could, at some point in the future rulemaking, address the concerns of the SCB discount rate, which it's very complicated. Apparently the parties can't solve that position right now, and it'll be an issue to be discussed in the future. Other thoughts on commissioners regarding the competing proposals?
So I have one more question for Mr. Seegers. Mr. Seegers, do you see the utility proposal as being more or less costly to the utility? And we're not talking about cost recovery here at this point, but more, is there a cost associated with the work group proposal that is addressed by the utilities proposal?
Commissioner, unfortunately, I don't have amounts that are associated with the joint utilities proposal. However, I would note that in our initial comments that were filed in October, we did say that in order to implement the work group consensus proposal, it would have been about, for BGE and PHI, about $14 million. And that's not including any customer education costs. The advantage of the Exelon proposal is that we would not have to set up our system to repurchase any distribution receivables. So even though I'm not able to give you a definite number, I would anticipate that it would be cheaper for the utilities to implement supplier consolidated billing under our proposal.
Okay, thank you. Mr. Chairman, I think at this point, while there's interest in the joint, I have some interest in the joint utility proposal. It sounds to me like it's just not fleshed out enough, and that if we need to be voting by the end of the week, then I feel, kind of constrained by the fact that it's not fleshed out and there's a lot still out there. So I would say for now, the work group proposal is probably where I am as well.
And I would also agree with Commissioner Herman. I have a lot of interest in the joint utility proposal, and would not want to close the door at this point to future consideration. Not the least of which because we have one supplier already that's using that process, it sounds like, or at least is supportive of the POR with a discount rate. So anyway, I also support the compromise work group position, but do again hope we can keep the door open to the joint utility proposal.
Same here. It looks like the compromise position, and with a lack of consensus otherwise, I don't know where else we go with it.
Commissioner Linton may be unavailable at this point, although we have 4 commissioners largely in the same camp. Mr. Baker.
Thank you, Chairman and Commissioners. Next on the schedule then, I would like to go over with you today is payment posting with the supplier charges versus the utility charges. And I would note that the next 3 topics are very interrelated. So that's the payment posting, supplier versus utility charges. This will be the suppliers bundled versus unbundled charges and how that will be handled in payment posting, and also payment posting of electric utility charges and gas utility charges on the same bill. I would like to take them in the order that's on the agenda because I think that would be the most efficient, but obviously if there's questions that cross over between them, we'll take that as it comes.
Mr. Baker, would it be more efficient if the commissioners provided guidance on each one of these issues first, or wait till we heard from you and the others on all 3? Are they interrelated? related enough where we should hold off?
I think if you would, let's see where I would say if you provide guidance on the supplier versus utility charges, that would, so the very first topic, that might have, if you know at the end of that discussion where you would like to go with it, then that will provide guidance on the bundled versus unbundled charges and the discussions of the implications of I guess, how it impacts the suppliers and customers. So depending on how you would like to resolve suppliers and utility charges on the same bill for payment posting purposes, I think that if you are ready today, we can have all three discussions without having guidance, but I think that one will help inform the bundled versus unbundled charge discussion.
Okay, Mr. Green?
I just wanted to point out that there are, the two are the payment posting versus the treatment of bundled charges are extremely related to each other. And I guess I would not want the commission to make a payment posting decision without considering at all the issue of bundled charges. I think there may be some, they are so overlapping that one will affect the other, I would think.
Okay, so you're advocating that we bundle them, the first two at least.
Yeah.
Let us proceed with at least the payment posting discussion now, and then we'll take a break afterwards before we tackle the bundled charges discussion.
Thank you, Chairman. Overall, I'll give an overall picture of payment posting, and then we'll dive into the supplier versus utility charges. So in the proposed payment posting structure that's before the commission, it is a pro rata approach where utility arrearages and supplier arrearages of the same age are given equal weight based off of the total amount of charges in it, and then followed by utility current charges and supplier current charges given equal weight. Within that, as Mr. Green just mentioned, that will be influenced also by how the commission decides to treat bundled and unbundled charges. And another subtopic to keep in the back of your mind will be if a supplier carries electric and gas charges on the same bill as well. But diving in, the competing proposals to the proposed regulations are a payment posting structure that follows similar to what is under UCB today, which is utility arrears paid first, followed by supply arrears, then utility current charges, then supply current charges, and then all other charges that may be on the bill. Alternatively, you could have supplier arrears paid first, followed by utility arrears paid first, then supply current charges, followed by utility current charges. The commission was cognizant of the issue of customers' distribution balances and the possibility it could lead to service termination when you issued your order last year. And you had directed the work group to identify and propose a fair and equitable payment posting priority and any other protections that may be necessary. And another crux of your order was to develop a payment posting hierarchy that minimizes distribution arrearages. Staff believes the pro rata approach is the most appropriate since it recognizes suppliers carry greater risk under supplier consolidated billing while also trying to minimize distribution arrears that could lead to service termination. This is effectively trying to meet the fair and equitable criteria while also balancing the criteria of minimizing distribution arrearages. Additionally, any customers who face service termination for not paying while on SCB will not face any service terminations for supplier charges during that time period. And this is what I was trying to discuss earlier and how this is significant because a portion of the customer's bill that would be eligible for service termination under utility consolidated billing is now no longer eligible for service termination. Finally, there are proposed limitations on the age of the debt that can be returned to the utility to protect distribution ratepayers from poor supplier collection behaviors. Therefore, staff believes the commission should uphold the proposed regulations implementing the pro rata payment posting system. Thank you, and I'm open for questions.
Let's hear from the petitioners at this point regarding their preference.
Sure. With respect to payment posting, as we stated in our comments, look, our initial going in litigation position was that we felt to properly address risk issues and to manage our bad debt, that the payment posting system should allow for partial payments to apply to supplier arrears first, then distribution arrears, then supplier current, then distribution current, and then value adds. Throughout the course of the working group and looking at the commission order, looking at the history of payment posting, especially what the commission did in the 2008 time period, we, again, as I said earlier, we've tried to be flexible throughout this proceeding. We've tried to understand and recognize the various interests and risks involved. So we agree to what we refer to staff's position as a compromise position, because it's not distribution first, but it's not supplier first. So we felt that that was the appropriate middle ground. It's fair and equitable, as the May 2019 order says it is supposed to be. We understand the arguments from the utilities and OPC that to mostly minimize the way to go to minimize as many potential terminations as possible is to apply partial payments to distribution charges first. We felt like we have to have a fair and equitable payment posting system that includes to suppliers as well. We also recognize or would point the commission to COMAR's 2053-05-06A and its counterpart in the natural gas COMARs at 59-05-06A. In that time period, back in 2008, when the commission was establishing the UCB POR programs, the commission essentially left it up to the utilities and said, you can have a POR program, or if you don't, you can do a pro rata payment posting system. Now, I think initially Washington Gas Light did a pro rata payment posting system, and then they later switched over to a purchase of receivables program. But the commission has authorized a pro rata payment posting system. So this is not the novelty act that some would have the commission believe that it is. So we looked at the fact that the commission has done this before, or at least approved it before, and the wording of the order of what is fair and equitable to everyone, and felt like staff's position was the appropriate middle ground. And so we would ask that the commission approve that payment posting system. Now, we do have other issues as far as how to treat bundled or packaged products within that payment posting system. I'm happy to answer questions about that, or we can talk about that after we talk about this. But I didn't want to think that I didn't have anything to say about that.
No, we expect you to have a lot to say in that discussion. But Mr. Green, just to make clear, you're saying that you've moved off your initial litigation position and you are fully supportive of staff's compromise position?
Yes, the pro rata approach is acceptable to the suppliers, to my clients. Yes.
We'll now hear from the third camp, which is the utilities and Office of People's Counsel, whoever would like to speak first.
Thank you very much, Mr. Chairman. Indicated in our comments, the joint utilities have the position that utility arrearages should be paid first, primarily because that is consistent with what the commission said in its order when it approved supplier consolidated billing. The commission very clearly said that suppliers should purchase that the payment posting should be done in a manner that minimizes distribution arrearages. And in listening to Mr. Green, I did not hear at any point where he said that what the petitioners are proposing is consistent with that. Moreover, under a pro rata approach, and you alluded to this, Mr. Chairman, supplier consolidated billing customers are actually going to be treated less favorably than they would under utility consolidated billing and dual billing, just because of the fact that when the utility has to repurchase the arrearage of a non-paying customer, that customer is going to have more of a distribution arrearage than they would under utility consolidated billing or dual billing, and therefore be that much closer to termination. So I know that Mr. Green he talked about the fair and equitable argument. But in that sense, it does not appear to the joint utilities that a pro rata approach is fair and equitable to customers.
Seegers, can I just?
Yes, Mr. Chairman.
I think that's a strong point for your side. A moment ago, you cited the May 2019 order where we stated that payment postings need to minimize distribution utility arrearages, but it didn't say eliminate. Is that correct?
That is correct, Mr. Chairman. So, but order as actually quite literally that the commission is of the mindset that distribution arrearages have to be minimized to the greatest extent possible, because that is what, as Mr. Green has noted on a number of times, the suppliers do not have the disconnection authority. The utilities have that disconnection authority, but it is the distribution arrearages is what customers are going to be disconnected for. Does that answer your question, Mr. Chairman?
It does. I just wanted to make clear on the record that while it said minimize, it didn't say guarantee that the utilities distribution arrearages would be fully paid in order of priority. You may proceed. I think you had a second point, sir.
I believe that was primarily it, Your Honor. It's just under the pro rata approach, a customer is going to be coming back to utilities with larger distribution arrearages and therefore be closer to termination than they would under utility consolidated billing or dual billing, Your Honor.
Thank you. Mr. Trout, are you still with us?
I am. I hope you can hear me.
We see you now. Yes. Good.
Okay, great. Can you hear me as well?
We could hear you.
Okay. Just let me know if I start fading and I'll turn the picture off. First of all, I agree with everything Mr. Seeger said. I have just 2 points I wanted to add. One is about compromise and the other is about the relative risks of the various parties. With respect to compromise, I think everyone is losing sight of the fact that the existing payment posting priority system is a compromise in that it divides the charges up over time. Within each time tranche, the utility charges currently get paid first, but utility current charges don't get paid until supplier arrearages get paid. And if the utility has any charges that are neither supply nor neither commodity nor distribution, those would likewise get paid after the supplier current. So there already is, to your point, Mr. Chairman, that you are not eliminating the possibility of utility arrearages that would result in termination, but you are we're trying to minimize them. The existing payment posting priorities are a compromise, and they're a compromise that have been in place for well over a decade. And the other point I wanted to make was about risk. It is true, and it keeps getting said about every 10 or 15 minutes, or perhaps more frequently than that, that the suppliers cannot terminate electric or gas service. That is true. But they are at a different and better position than the utilities in two substantially material respects. The first respect is that with the very narrow exceptions in COMAR that I pointed out to you at the beginning of today's discussion, the utility has to serve everybody who applies to it. We cannot pick or choose our customers. The suppliers can. We have the obligation to serve. The suppliers do not. this, so they can craft their portfolio of customers. We have to take everybody, including everybody that they reject. The second critical difference is they can drop a customer very easily and very quickly. We cannot, the only way we can, quote, drop, we can't tell a customer, sorry, you have to go off and get service from a third-party supplier. We're not going to serve you on standard offer service anymore. We can't do that. The only way we can drop a customer is cutting their service altogether, and that is a long, convoluted, and very highly regulated process. So respectfully, I while I've never worked in the retail supply world, I have an appreciation for the complexities and the business risks associated with their business model. But respectfully, we the utilities have different and substantial risks as well that I would submit that relative weighting of risks likewise is well captured in the existing payment posting priorities, and that we should not adopt what staff is proposing as a compromise. I view as a radical change, and it's a radical change that among other things will disadvantage customers.
Thank you. Office of People's Counsel.
Thank you, Mr. Chair. I'll keep my remarks. But as stated in OPC's comments, we believe that the scenario that staff had included as one of the proposals to pay utility arrearages first is the proposal that is most consistent with the Commission's operational order in this case. And we also believe that it's the proposal that is most consistent with the public policy of seeking to avoid utility service terminations. By having utility arrearages paid first, the amount of utility receivables that would be subject to repurchase would be lower than it otherwise may be. And therefore, we would join the utilities on this point and request that the Commission adopt the alternative proposal that staff had included, and rather than the pro rata approach.
Thank you. Looks like I forgot one of the utilities. Mr. Kane, Washington Gas Light.
Yes, we just wanted to sort of reiterate what Mr. Trout has said, that it is completely difficult for the utilities to turn off customers for arrearage. But also, I just wanted to correct Mr. Green. Washington Gas never implemented a pro rata system. We did originally in RM35 did consider it, but we never implemented any type of system.
We have that clarification on the record. Thank you, Mr. Kane. Any other parties wish to discuss payment posting?
Chairman Landon Farrig from MEA.
Hi, good afternoon, Mr. Farrig.
Good afternoon. Thanks so much. I did just want to address a couple points. I appreciate that the chair has noted the difference in language between eliminate and minimize. This is a point that was discussed within MEA, and I think it's appropriate given what petitioners have brought up, which is the ability to conduct a shutoff. But also Mr. Trout missed another advantage or difference for utilities, and that is that they have a franchise. So I think we must balance the risk competitive suppliers are taking on. Ultimately, I guess that leads us to concur with the petitioner's concession and their most recent filing, where it states staff pro rata approach is a middle ground solution that's in line with the order 89116.
Thank you, Mr. Farrig. I'll turn to my colleagues now to see if they have questions of the parties.
I have some questions, Mr. Chairman.
Yes, Chris.
Thank you. So presumably, Mr. Green, it is the suppliers who determine the pro rata amount. Is that correct? Under the pro rata proposal?
My understanding of the proposal is that as partial payments are received, the supplier applies the partial payment according to the payment posting system and has to keep records of that in order to show as the Chapter 5, Section 13, upon the commission's or utilities request, they have to show how they applied the payments.
Mm-hmm. And from the utility standpoint, Mr. Seegers or Mr. Trout, does the utility have to revise its systems to accomplish a review of whether or not they receive the appropriate amount? And if so, would that be in addition to the cost of the $14 million, or is the $14 million based on the pro rata proposal?
$15 million is based on the pro rata approach.
And if we went to the if we adopted the current payment posting, would that result in a reduction in cost?
In hard dollars, the fact that we are still going to have to repurchase the distribution arrearages means that we are going to have to incur a large portion of that cost. I think the advantage, as I discussed with the chairman, is that when customers come back, they will be less likely or less closer to disconnection.
Okay, and Mr. Green, you suggested that because of the risk associated with supplier consolidated billing, we should change the payment posting process that has been in place. If a supplier doesn't want to bear the risk, they don't have to offer supplier consolidated billing, do they?
No, they don't, but we should be building a program that encourages suppliers to participate, not creates barriers because of too much risk to take on up front. That's what we are driving at. And,
well, does this create a barrier, or is it just simply this is better for suppliers? I mean, there's a difference between creating a barrier and making something better, because you're talking about risk, and the suppliers don't have to do this if they feel like it's too risky.
Right. To the extent that suppliers are taking on costs up front, and then when they get a partial payment, they aren't able to apply it initially to supplier arrears. There's risk there, and so we are proposing or agreeing with staff that it should be a pro rata approach, which I would add that if that same customer was still on UCB, right, instead of switching over to SCB, the utility could terminate them for failing to pay supply charges. So the pro rata approach, there's been no data introduced that if you make that comparison, the same customer that doesn't pay on UCB versus that same customer on a pro rata versus distribution payment posting system, how quickly do the unpaid amounts build? You have a limited number of or amount of dollars of with the SCB that's related only to distribution versus a much bigger amount that's subject to termination under UCB. So it's the comparison of just looking at what happens on UCB is doesn't tell the whole story. So as far as how to design a fair and equitable payment posting system for SCB.
Okay, thank you very much, Mr. Chairman.
Okay, at this, Commissioner Richard.
I just wanted to follow on to Commissioner Herman's questions, Mr. Green. as was discussed, what we heard from some of the representative utilities, the suppliers will still have the benefit of being able to screen or even select their customers. Doesn't that mitigate to a large extent that risk? I mean, isn't that because I'm interested too in this barrier versus what's better question.
Right. I mean, I think the purpose of credit screening is to mitigate risk. I mean, if that answers your question, and that's why they do it, and that's why some suppliers do a whole lot more of it than others and have higher standards, and some have lower standards. It's that's the in other markets, because UCB is not. I don't know how much credit screening there's going on in the UCB market, right? But I agree. I mean, credit screening is designed to eliminate the risk of non-payment.
Okay. Yeah, just as I'm looking at, okay, how do we come up with a workable program? We want to make, at least I would like to see it be successful, but at the same time, I think there are some important customer experience issues that we need to be mindful of. And one, for those rare occasions when there is a rearage, doesn't that seem to be, again, for the customer experience, an important thing that we take into consideration?
It is, but I mean, you also have to weigh if you have a distribution arrears first payment posting system, does that mean that the supplier's credit screening is going to be elevated? Right, they're going to take fewer customers because there's more financial risk on a going forward basis with that customer, or are they going to lower the standard a little bit and let that customer into the program? So there's where all of this risk balancing and tools come into place, and so I agree again that credit screening is very important, but the levels of how you use that credit screening with respect to the payment posting system are very much related.
Okay, great. I appreciate that, those answers. Thank you, Mr. Chairman.
I'm ready to share some thoughts if you'd like.
Commissioner O'Donnell, since this issue is so closely tied to the next one, bundling, I thought Mr. Green made a good point where we could share these thoughts together. But you are free to share thoughts now on payment postings if you prefer.
No, I think I can hold my thoughts cogent through another one of these very exciting discussions.
Okay, thank you. At this time, looking at the clock, it's 1 o'clock. If the commissioners have concluded their initial round of discussions on payment posting, we will take a short lunch break now, although recognizing that we will not be finished by 2 o'clock. And I wanted to see if any parties or commissioners had concerns with running until 3 p.m. this afternoon. Okay, seeing none, let's take a lunch break until 1:25 this afternoon. That'll give us about 20 minutes. 1:25, we'll come back, and then we'll hear from staff and the parties regarding bundling versus unbundling charges.
Mr. Chairman, I know that I have a commitment at 2:30, a hearing in another case, and I believe that there might be some folks on this call that has a similar conflict.
Yeah.
All right. Well, let's see how far we get by 2:30, and we may adjourn at 2:30.
Okay. Thank you.
We're in recess until 1:25. We'll start up again in about 1 minute. We'll have some off-the-record remarks before we begin. Before we go back on the record, just two things. One, if parties can do their best to see if they have some flexibility for the remainder of the week to run an additional hour, that would be appreciated. Additionally, as I mentioned, Monday we are scheduled to start at noon. If parties are available to start at 11, that would be my preference. If you have any conflict, however, please let staff know, and they will relay that information back to me. One more item.
I think you meant Wednesday. You said Monday. I think you meant Wednesday.
I'm sorry, Wednesday. Yes, Wednesday we're scheduled to start at noon. If we could start at 11, that would be great.
And then each day, each Tuesday through Friday, be ready to go till 3 o'clock instead of 2 o'clock. Is that
correct? Yeah.
Okay.
If we need additional time.
Okay.
Lastly, before we return to the record, I recognize this for the interested parties. This is the first time you're hearing directly from the commissioners since our order back in May of 2019. Obviously, as we provide insight as to where the commissioners are on some of these top line issues, that may change the leverage of negotiation between some of the parties going forward. We've allowed the schedule to have the parties have the afternoon free to have further discussions, and that may be helpful as you receive more input from the commission. Additionally, we're not planning to discuss any red line language today. However, beginning tomorrow, we will have that red line on the screen for the commissioners to view and make changes to. So I just wanted to note that and hope the parties are using their time productively after these sessions conclude around 2 or 3 o'clock. But today we will conclude by 2:30 to accommodate the schedules of others who were not able to go longer. With that, we're going back on the record. Mr. Baker, if you will address
We're
the
on the
next.
record.
Oh, Mr. Baker, if you will address the next issue regarding bundled charges.
Thank you, Chairman. Good afternoon. So item 2 inside the payment posting discussion that we were having this afternoon is the treatment of bundled and unbundled charges within this payment posting structure. One of the advantages of supplier consolidated billing is to include other items on the bill unrelated to the supplier's commodity service. And one such way of doing this is through the bundled products, where the value-added service is combined with the price of the commodity. This has implications through treatment of such products in both the payment posting structure and in marketing. For payment posting, the proposed rules give a supplier with a bundled charge 2 choices. 1, the supplier can unbundle the charge, and the value-added portion of the charge is paid last, and the commodity portion is paid earlier based on age. Or 2, if the supplier cannot or chooses not to unbundle the bundled product, then the entirety of the charge is paid last. For marketing purposes, the supplier may represent the bundled charge as commodity in its marketing, but within the customer's contract, the supplier must disclose the portion of the bundled rate that will be treated as commodity for payment posting. This does not mean the supplier must separate the charges, but the supplier will inform the customer how their charges will be treated for payment posting, which has implications for possible service terminations later. Suppliers oppose this requirement and believe the proposal should be struck. Instead, suppliers believe the bundled charges should be treated as 100% commodity for payment posting, which in turn would nullify the disclosure requirement about payment posting. Staff continues to support the proposed regulations. The overarching question when discussing bundled products, though, is its influence on possible service terminations and the distribution uncollectibles that would be paid by other ratepayers. If bundled products are treated as commodity under a pro rata system, then value-added products may siphon away funds from the distribution charges. Today, under the UCB, suppliers are not supposed to sell non-commodity charges to the utility. There should not be an influence of non-commodity charges upon the discount rate under SCB. The Commission charged the work group with developing a payment posting system that minimized the distribution arrears and was fair and equitable. Once again, in combination with this pro rata system that has been proposed, we believe that the unbundling of the charges for payment posting or the payment of bundled charges that cannot be unbundled paid last strikes this balance of minimizing the distribution arrears while also providing a fair and equitable option to the suppliers. Another solution that was explored but we did not pursue was a proxy price for commodity when compared to bundled charges. A standard price would be developed that would represent a supplier's commodity cost. Parties did not pursue this solution, citing difficulty with developing a reasonable proxy price. Another issue to consider is the supplier's enrollment choices. Whether the Commission approved, well, as we were discussing today, we are likely to be facing an eligibility requirement. And so the supplier, but whether that happens or if the pre-enrollment information is given, the supplier has the tools to manage their choice to enroll a payment risk customer. And finally, we would also like to clarify that the proposed rules should not require a supplier to unbundle their costs of business, such as administrative and general, their call centers, that is necessary for that supplier to provide their commodity service. Finally, staff does not believe the proposed regulations hinder a supplier from offering bundled products. Suppliers are given the option to unbundle their charges or have their charges paid last. It is the supplier's discretion. The proposed marketing rules inform the customer of the implications on the bundled rate influencing a possible service termination. Thank you, and I'm available for questions.
Thank you. We'll hear the positions of the various suppliers, beginning with the petitioner.
Thank you, Your Honor. So we've filed voluminous comments on this particular issue in addition to the payment posting and how the two are interrelated. Suffice it to say, the ability to sell bundled or packaged products is very important to my clients. I disagree with staff's comment that they're not prohibiting these products. That's true on its face. But given the difficulty of carving out the price of the bundled product from the commodity itself, it creates significant financial risk. And if you can't do it, it would move everything, or it would move the commodity price to the end of the payment posting line. So when all of this discussion began to occur in the working group process, we started looking at some of the other jurisdictions where SCB is allowed and how do they handle this. And we landed on Texas, quite frankly. And I know in their comments, staff says, the Texas structure is just so different that it's not helpful here. And I'm paraphrasing. The Texas structure is different. It's unique, but billing is billing. And in Texas, the supplier sends out the bill. The supplier can terminate for non-payment, and the supplier has a payment posting system, which is basically pay the oldest first, and then the value-added product gets paid last. So our proposal in looking at the specifics of the Texas rule goes like this. So if there is a value-added product, and these are our red lines, so I just want to give a high level. If there is a value-added product, meaning it is sold separately from the commodity, the customer does not need to purchase that product if they don't want to. And an example that we've used is a home warranty product. Let's say it's a $9.99 a month. That product is going to be a separate line item on the customer's bill. It will be fully disclosed in whatever contract, and that it will be paid last in any payment posting system that we've been talking about, right? So for partial payment purposes. If, however, the commodity price includes the something else, a thermostat, a Google Home, some of the other types of products that we've seen in the market in other jurisdictions, then that would be included as the supply price for purposes of payment posting. And our view is that that this is a fair and reasonable way to handle this. That Texas actually had these identical discussions years ago. They implemented their rules. To our knowledge, they've seen no systemic problems. It's certainly not enough to warrant revisiting the rules or having an investigation into whether there was a big price difference when you added in the bundle. And I would also add on that regard, whether there's a price difference or not, is that rightly or wrongly, there are products in the market today in Maryland, and we pointed this out in our reply comments. You can go to the Commission's shopping websites, mdelectricchoice.com, and you will see commodity plus something else products that are priced below the SOS price. You'll see them priced above the SOS price. You'll see commodity only below the SOS price and above the SOS price, all for varying durations. So there's no data to support this view that there's going to be a huge price difference if you adopt the rules as the petitioners have proposed them. And in fact, we would suggest adopt them, allow for a friendly market so that suppliers can come in and offer these products, which, by the way, customers really like. Virtually everyone that commented on it identified different types of bundles that they see in the market, whether for energy or non-energy products, everything from cell phone service to cable to insurance, lawn services, Happy Meals. I mean, there's all kinds of customers like bundled products because they can get multiple products at the same time, typically at a discount. And our thought is let's adopt rules that encourage those types of products. And then it's consistent with the discussions from this morning, as we continue to monitor the implementation and the success of the program, we can make tweaks as needed on a going forward basis. But we have significant problems with how the current rules, the proposed COMARs would be implemented and the effect it would have on the market. And I'm happy to tick through those. They're all in our filed comments. But the initial problem is that there's not a one-to-one relationship between the supplier's cost and the price they're charging the customer. So it's not, what is being proposed is a very black and white solution to something that is not a black and white situation. You can't just say the cost of this particular item was X and I'm going to lift that out. It doesn't work like that. And there's multiple reasons why that's the case. And including that lots of factors go in when a supplier sets its price, and including not just the cost of the particular items that make up the price. And don't forget, when a supplier sets its price, it's everything, right? It's everything from IT to office space to everything. Whereas in SOS price, it's the cost of the energy procured on the wholesale market plus the administrative charge. So, but for the supplier, it's everything. But at the same time, you're going to look at what are your competitors offering. If the competitors are offering the same type of product, but at a better price, then you need to do something about that, or you're not going to stay in business very long, right? Or at least not have a whole lot of success with that particular offer. So some suppliers will look at the cost of the bundle as just an acquisition cost, an increased acquisition cost, and they'll say, we're not including any of it in our energy costs. This is just an additional acquisition cost, and it may also offset marketing. Whereas on this product over here, I have to do a whole lot of marketing because I don't have a bundle with it. But over here, it almost markets itself, right? Because it's a very attractive offer that customers really like. So over here, I have very few marketing costs, but over here, I have a whole lot more. but I have a little bit more added expense perhaps with the bundle product. So it may actually be cheaper than the energy only product. So the other types of problems that arise here is we've talked this morning about how does the supplier show that they're properly doing the payment posting system, right? Does the commission audit that? What kind of reports are we filing? Is a utility or the commission or staff going to come in and say, we think that that bundled product, that thermostat, that whatever, actually costs more, and you didn't properly weed it out of your total price? What if you have two suppliers and they have the same offer, the same product, the same bundle, right? But one is saying it's $100, one is saying it's $50, right? So it just creates all of these complexities and uncertainties, and quite frankly, real enforcement problems, if that's the road that we're going to go down. And the other issue, quite frankly, is if I offer a thermostat and I say it's $100 retail value, but it didn't cost me $100, but if the customer went on the market to get it, it would cost them $100. What price am I submitting? The $100 or what it actually cost me? And are you going to look behind my books to see what it actually cost me? So there's all of these issues. And then at the end of the day, whether we unbundle and weed out that cost, it's not really helpful to customers, what we see. Because first of all, like I said, customers like these products and they understand that they're getting hopefully really good value because they're purchasing multiple products together. But they're going to be able to see the supply price comparison, right? They know the utilities price. They can research or go online easily on the commission's website and see what kind of other offers other suppliers are offering. And so they can do that cost comparison, that sales comparison, to see are they getting a good deal or not. And then they'll also know if they went online and tried to get that other product solo, how much would that cost? So the idea that the customer needs the breakdown of the information of what it costs the supplier to offer these two products together, it doesn't add up with what we see in the market for all these different kinds of products every day. So the supplier under the rules is going to disclose that there's an energy and there's the something else that goes along with it. That'll be in all of the disclosures. That'll be in the contract. I believe there's an incentive row in the contract summary right now where it has to be spelled out. The customer will be fully informed of what they're buying. And then it will show up as the supply price on the bill. And I would imagine it'll be up to the supplier that they're probably going to want to highlight the fact that, thanks for using this product, or you're going to get, because of you have this extra product, maybe you get it allows you to get additional energy reports on a daily basis from the supplier, or it allows for something else. So those are some of the reasons. And then the last reason is that it also creates uncertainty as to, I know staff and the others want to paint this very bright picture or bright line between what's commodity versus what's non-commodity, but we're not seeing it. And so what is a non-commodity product? And the examples we've used in the working group is, if I have a product that involves an energy audit report of your usage from the day before, and I get that to you on a daily basis, is that a value-added product that I need to unbundle the cost for that? What if, for call center purposes, I offer 24/7 call center services, whereas everybody else only does 9 to 5 on Monday through Friday? Do I have to weed out the cost of the additional call center hours to report to you all and to put in the payment posting? There's all kinds of complexities on that, on what exactly is a bundled product. So our thought is that the easiest and most effective way to do this, and most efficient way to do this, it is to allow it to be part of the commodity. And what WGL Energy filed comments and said the cost, they see it, any additional cost is negligible. And there's been no data to, as part of this case, that says that this is going to lead to some dramatic price difference that's going to increase service terminations down the road. So Our position is that with respect to the price disclosure, Comar, in 530709, with respect to the proposed payment posting in 530512, and with respect to the bill format in 5309, and all of the natural gas counterparts, we've proposed red lines to capture what I just explained. And I'm happy to take any questions. And we have, like I said, I have Ms. Gibbons and Mr. Schatz on the line as well if you need more like real world type experience of what's happening.
We'll now hear from any utilities that wish to comment.
Thank you very much, Mr. Chairman. Matt Seegers speaking for the joint utilities. At the outset, Your Honor, I would like to make clear the point that the joint utilities made in our reply comments, that we have no objection to suppliers offering bundled products. We have no objection to them bundling those rates on their bills or their marketing materials. What our concern is that suppliers must have the ability to unbundle their products when it comes to payment posting. And I would argue that this is a more clear-cut issue than the general payment posting issue, because you have the same issue whereby supplier consolidated billing customers are going to be disadvantaged because they're going to be coming back to the utilities with larger distribution arrearages than they ordinarily would be. But the reason that would be under the unbundling issue is because a portion of their dollars would be going towards a Netflix subscription or a gift card or a mini fridge. And the joint utilities believe that is just completely unfair to put supplier consolidated billing customers at risk, at more risk of being disconnected, just to have those non-commodity products paid for. And the suppliers really have not offered any real explanation for their position other than the fact that they simply want this. There's nothing saying that they have to offer non-commodity products, and they simply want to do it. As staff indicated earlier, the suppliers already have the ability to unbundle their products. As the joint utilities noted in our reply comments, under our supplier coordination tariffs, the utilities only purchase the commodity portions of the supplier receivables. So they already have the ability to unbundle these, Your Honors, and I don't see how they would lose that ability under supplier consolidated billing. As we also noted in our reply comments, regarding energy assistance, I know that a number of parties in this proceeding, including the joint utilities, have said that we should hold energy assistance customers to a phase 2 of this proceeding, and we support that. However, when energy assistance customers are taken into account, those energy assistance funds, in a lot of cases, cannot be spent on anything other than the commodity portion of a customer's bill. And we cited LIHEAP as an example in our reply comments. And in terms of the administrative costs, first of all, I would like to note that there appears to be a factual error in the reply comments of the petitioners. They say at one point that utilities get recovery of our administrative costs for SOS through our regulated distribution rates. That is not correct, Your Honor. There is a specific administrative charge that is set by the commission where utilities come in with our administrative costs, our uncollectibles, and other factors, and that is what gets included into our SOS price. And the joint utilities would have no objection to the petitioners including similar administrative costs. But I find it surprising that the petitioners are saying that they don't know what constitutes a non-commodity cost, because I know that the RESA, the Retail Supplier Organization, has taken part in those SOS administrative cost proceedings. So,
okay, going further afield.
I'm sorry, Mr. Chairman?
little further afield than the topic that we're trying to address here.
Understood, Your Honor. I'll bring it back. Those are about all the points that I wanted to make, Mr. Chairman. Thank you very much, and we're available if you have any questions.
Thank you. Before turning to the state agencies, any other utilities?
Good afternoon, Mr. Chairman. Jeffrey Trout for Potomac Edison. First of all, I agree with Mr. Seegers. He made the points very well, both in his written comments on behalf of the Joint Exelon Utilities and today before you. Secondly, Potomac Edison discussed this issue at some length in its December 4th reply comments, and most of what I would have wanted to say is already covered there, probably better than I can do it orally now. So mostly I would refer you to those reply comments. I just have one additional thought to add now. In our reply comments, we argued that the suppliers must be able to differentiate between the cost of a Netflix subscription and on the one hand and their commodity price and their back office prices on the other hand. That would still seem to me to be what logic would dictate is the likely outcome. But if I have a tremendous amount of respect for Mr. Green, and if Mr. Green is representing to you that the suppliers can't do that, or that they can't do it in a way that is economical, consistent with being able to offer the products, so that if they have to segregate out the costs, they're not going to offer the products because they can't, as opposed to, they don't want to or they won't. If that's the representation that petitioners are making, then we have to take that representation seriously. And you are left with two choices then, unless you're going to take Netflix dollars and lawn service dollars, and you're going to put those dollars ahead of utility distribution charges for which a customer could get terminated. And I cannot see that as being an appropriate outcome. So your two choices are either adopt some sort of procedure for figuring out what the costs are, perhaps on a generic basis, and there didn't appear to be much appetite for that in the work group, but I just point to it as an alternative. The other alternative, and Potomac Edison has not joined this alternative as offered by staff and the Office of People's Counsel until now. But if it really is the only alternative, I guess we would join it. And that is, if you can't unbundle the costs, then you put the bundled costs last, because that's the only way you're going to accomplish the result of not running the risk of terminating customers because the supplier had to get paid for the Netflix subscription or the lawn service or the other things that are on that wonderful list that's on page 10 of Mr. Green's December 4th comments. And it's a very interesting list, and I refer your attention to it. But Potomac Edison has not taken that position up to this point, but in light of Mr. Green's representation, I guess we have to give it very serious consideration.
Thank you, Mr. Trout. Have respect for Mr. Green. You referred to his comments and position here. I believe it's a gymnastic tour de force. Colorful language. We'll turn to state agencies, if either of the two remaining state agencies wish to provide comment.
Thank you, Mr. Chairman. Jake Alexander on behalf of the Maryland Office of People's Counsel. I will be brief. The OPC has stated its position on this issue in both rounds of comments in this case, and we have also raised our position on the this bundling issue and previous dockets considering supplier consolidated billing for DECA Energy, and we believe that the public utility article and the Commission's previous orders have recognized that what staff has proposed is what is required under the Restructuring Act. A core component of the act is the unbundling of utility charges in order to allow a customer to engage in price discovery. And so, we believe that what staff has proposed is a path forward that would permit a supplier consolidated biller from offering bundled products, but would not permit them to, to confuse customers or to eliminate a customer's ability to engage in price discovery. We also agree with the comments offered by the utilities when it comes to payment posting. Certainly, if there is a bundling of non-energy products with energy products, and then there is the payment posting, the treatment of payment post priorities as the petitioners would recommend that the Commission adopt. The Commission certainly could not be sure that non-energy related charges are being put ahead of energy related charges. So for both of those reasons, we actually strongly support staff's filed proposal, and we would urge the Commission not to adopt the changes being proposed by the petitioners and other suppliers.
Mr. Auslander, if you could mute yourself. Commissioner questioning.
Chairman, I'm so sorry.
Oh.
Landon Farrig, MEA.
Mr. Farrig, MEA. Yes. Good morning.
Thank you, Chairman. I just wanted to offer a quick word and counterpoint here on the benefits of the marketplace at large. As stated in its October filing, MEA appreciates thoughtful, cautious, targeted regulation. However, the petitioners here and other competitive suppliers have been clear that this apparent animus toward bundled products will have a chilling effect on the market entry, and therefore hinder competition. The benefits of this competition aren't just felt by those who select a competitive supplier. The benefits can be felt by all Marylanders. Historically, retail rates in wholesale electric competition states have increased less than in states without those restructured markets, creating a significant value in Maryland. From 1990 to 2014, a review of percentage changes in weighted average prices in both nominal and real terms shows that retail choice states had the best price outcomes for residential, commercial, and industrial customers. And I would add that the retail choice has also been a boon for green sales. Green pricing programs offering customers the option of buying power from environmentally friendly sources. That growth in retail choice states resulted in approximately double the volume of green sales by 2013 as compared to those traditional states. So there are more widespread benefits, and I think that they should be taken into account when we talk about a spreading of the risk against or across certain populations. That the benefits are also spread across those populations.
Thank you for that testimony. At this point, we'll turn to the commissioners to see if they have any questions for the parties. If the commissioners do not...
I do, Mr. Chairman.
Commissioner.
Thank you. Mr. Green, is there, part of my concern is there's no limit to your proposal. So for example, I could get an offer to replace all the windows in my house with energy efficient windows and combine that with my supply. and get a bundled price for that. So maybe that's, just to make the math easy, $24,000 worth of windows. And so then I end up paying $750 a month for 3 years. Again, just making up, numbers that probably doesn't add up to 24,000, but you get my drift. I mean, isn't it possible that, these very large amounts could get, under your proposal, my windows might end up getting paid for by the ratepayers if I don't pay.
Your Honor, experience from other states leads us to believe that you're not going to see new windows. We're not in the business of selling appliances with our energy. In fact, some of I threw out a bunch of bundles that customers are familiar with in today's market world as examples of how familiar customers are with purchasing. Right? So, but the idea that we're going to see mini fridges, as Mr. Seegers said, or brand new windows all across your home, or some big ticket item, we're not seeing that in any other market. And I would also point out that if that happens, like if there's a $750 a month, remember that's in our proposal, that's in the commodity portion, right? So we're on the hook for that too. Right? So if that customer doesn't pay, sure, we can drop them back to the utility and get repurchased, but that unpaid significant $750 a month times however many months it might be, the supplier's going to have to eat that or try and go collect it. And you don't see that in the marketplace today in other states. And I noticed that Ms. Gibbons is wanting to chime in. So if I may, if that's okay with the commission.
Yeah, no, honestly, Brian, I was just sort of getting on screen in case I needed to chime in, but I think the way you answered it actually is exactly right. I mean, we've been in the Texas market, for example, for, 15 or 20 years, and the kind of product, Commissioner Herman, that you're asking about is just not something that we have seen. I think, Brian said it really well. When we talk about the kinds of bundles that we're doing, I mean, all you have to do is look even on the Commission's own website to see the kinds of bundles that are happening. These are not, they're not things that are such game changers. The kind of thing that you're talking about with windows or with appliances, I mean, from my perspective, and, we're very active in the market in terms of trying to attract customers with value-added kinds of products and services. Those are the kinds of things that you put in a true value-added type of separate charge, right? So in Texas today, we do offer home warranty service. We do offer home security service. Those things are not bundled with energy. The bundles have limits, right? I mean, consumers are paying for these things on a price per kilowatt hour. You can't price that in to a commodity charge in a way that's reasonable, that a customer would actually be willing to pay. We still have to compete with all of our other competitors in the market and with the SOS price. So you have to be within the realm of reasonableness and possibility, because at the end of the day, the customer is going to be paying for this on a price per kilowatt hour basis. And if the supplier's charge was, something really ridiculous, 25 cents a kilowatt hour, no customer is going to sign up for that. And so that's not the kind of thing we're talking about when it comes to bundles. We're talking about things like miles and points and rewards and things like that are marginal, but that we find customers love these things. And so it's not a huge cost factor so much as it's something that is very appealing and attractive to consumers. It gives them a little bit extra into their energy consumption that they just kind of earn as they go. I mean, we're all consumers in the market today. We have credit cards that you earn your miles, or rewards programs at the grocery store. I mean, those kinds of things are so standard, and it's something that customers are so used to.
Okay, if I could interrupt, you're beginning to testify here, and it's going a little far from the commissioner's question.
Gotcha.
So let me ask you another question, Mr. Green, and would you say that a bundled product allows a customer sufficient information to evaluate the price and service for that product?
I think if disclosed upfront, like is in the rules, the customer will understand that they're going to get the energy commodity and they're going to get this separate product. And then if it's what we see a lot of, quite frankly, are thermostats, Nests, Google Homes, things like that. And so they know they can research what those cost if they want, what the retail price is. And so customers will know exactly what they are purchasing when they sign up with the supplier. Just like today, I should add that like when I go buy a Happy Meal, I don't know exactly what McDonald's costs are for each of the individual components in the box. When I buy a car, I don't know all the individual, I don't know how much it costs to do the engine.
Well,
right?
hold on a second, Mr. But we have rules and we have statutes that require that customers be able to compare the price of electricity they get from a supplier to the standard offer service price. That is clear in the statute that people need to be able to do that. We're not talking about Happy Meals. We're talking about regulated versus non-regulated services here. So those are really not, that is not an analogy that I find at all compelling.
Very, very understood. Very well. But when I make an offer, when a supplier makes an offer that includes a bundled product, that customer has the supply price comparison or the PTC that they can go and see what the utility price is. They can go online, like I said earlier, and see what other suppliers are charging for energy only or energy for whatever else products of various durations. So in addition to the disclosures that are made by that individual supplier when marketing to that customer and in the contract and contract summary. So there are a wealth of disclosures and resources that customers use in the marketplace, just like they do today, to make informed decisions and give consent as required under the COMARS.
Okay, thank you, Mr. Green. Thank you, Mr. Chairman.
Mr. Green, Commissioner Herman mentioned an example of Windows, but I'll go back to the example you provided, Happy Meals. And as a commission, we don't regulate retail energy supply prices. We don't regulate Happy Meals or lawn care or home security services. I found Mr. Trout's argument to be somewhat compelling that while you're still free to offer a bundled product and you could have a fixed price on that on the bill, on the back office end, you should be able to figure out what the cost to you was of that smart thermostat or of that Happy Meal sandwich to your customer, no?
I think what I am seeing and hearing is that they can figure out a number. Yeah, it may be 100% accurate and it may be a lot of guesswork because like I said earlier, there's a lot of factors that go into setting that final price.
Well, why is it guesswork? Your suppliers would know the cost of the Happy Meal.
Right. I mean, like I said, they'll know a number that they can put on it, but is it my wholesale cost, again, is not going to be what the retail cost is if the customer had bought that item separately. So I would hope not, right? Because that's the idea.
To address MEA's concern that customers may be confused if we require that each line item would be transparent on the bill, and I'm not saying that. I'm saying that suppliers could offer the bundled product, but behind the scenes, you know all of the components going into your whatever your bundle includes. And in terms of the priority of payment, we would add those costs towards the end instead of giving them the same level of prominence as a commodity charge.
Right, but that still takes you back to the ability to unbundle and all of getting it right, first of all, and then second, the questions that pop up in response to it. So let's say we unbundle on the payment posting side, on the back end, and the utility comes back and says, "Yeah, I don't think that's an accurate calculation. Prove it." And so where does that get us? That gets us at auditing the supplier's pricing to determine if they've accurately calculated the cost of the bundled product.
Well, that would be an issue for the commission to decide. I think that's a worst case scenario.
Right, but it also, sorry.
Where the utilities would be asking for an audit of each of the components. And I'm not sure how many components we would be talking about in a bundle. I guess it's depending on what the customer chooses, but I really don't see how difficult that would be for a supplier to do. They would have a standard price for what they paid for a thermostat, standard price for what it costs to run the call center for 1 hour. So at this point, I'm not terribly convinced with the argument.
Mr. Chairman, may I allow Mr. Schatz from Vistra to respond to that?
Briefly.
I see he's logged in, so.
Sir, you're on mute. Mr. Schatz, you're on mute.
Thank you. Thank you, Mr. Chairman. As a reference point from a supplier standpoint, a bundled product, be it a 6-pack of LED light bulbs or a thermostat, in some ways is regarded as no different than a marketing cost. Rather than sending out 1 million mailers to potential customers, we may just post an offer that, sign up with us and you will get LED light bulbs, just purely as a reference point. A lot of times bundled offerings are interchangeable with marketing programs, just a different form of marketing, different avenue to acquire customers or retain customers.
Yeah, I think that's a little different though once you go into marketing and marketing expenses if these light bulb giveaways.
Thank you.
Thank you. I have no further questions. Commissioner Linton.
So thank you, Mr. Chairman. So I actually had a question for Office of People's Counsel. I've heard their thoughts already on this topic, and since they've been tracking supplier rates for many years now, and been posting it on their website, I'm curious about their thoughts, specifically because I think it was Mr. Green or one of the other parties just a few moments ago noted that there are a number of bundled offers already on the Commission's website, and we've had them on there for many years. Currently, to my knowledge, there's those prices, to the extent those costs exist at all, they are bundled in with the commodity. Has OPC found that to be the case? Have you seen that at all in terms of what we have currently happening?
So, Commissioner Linton, the charts that are compiled each month just use the information that we are able to obtain from the suppliers' websites. And so to answer your question, we don't know exactly whether there, a particular supplier charges for that Netflix included in the bundle price. I would assume that is the case with many of these promotional offers, but it's possible that there are other arrangements out there. I know that the way I understand the supplier coordination tariffs with the utilities, there are certain things that the supplier is not supposed to put on a utility consolidated bill as a commodity charge if it is if, for example, an early termination fee, and presumably that would also include non-energy related items that are charged for separately. But I also think that the question that you're asking is interesting because it shows that to the extent that some bundling is occurring in Maryland, it seems that these suppliers that are offering those types of products are essentially including the costs of obtaining that added benefit and rolling it into the energy price that they put on the utility consolidated bills each month. And going back to staff's point, OPC agrees that what is being proposed is not a prohibition on the bundling that petitioners and other suppliers seem to want to engage in. What it is a real reflection of the fact that the law is very clear that these utility charges need to be unbundled so that customers can engage in price discovery.
So what is your response then to what the suppliers have suggested that unbundling, we're talking about just charging, allowing the utility to purchase the commodity only costs as opposed to back end expenses and all the other stuff that was mentioned earlier. And just as an example, by way of reference, historically, and I picked on OPC on purpose because historically, you know that there have been occasions where we've had some suppliers pass commodity costs onto the utilities through purchase of receivable that were 3 and 4 times higher than the SOS rate. So we know it wasn't all commodity; it was something else, but we don't know what it was. Most of those companies aren't around anymore, but it's happened before. So I'm curious about what your thoughts are in terms of how the company would, a supplier would unbundle those costs, and how do we know that they're accurate if the commodity was procured, wherever it was procured from, wholesale market, private contract, whatever. How do we get back to that point of saying, yes, this is the commodity price that should be purchased by the utility?
Well, I'm not sure, Commissioner Litton, whether the examples that you're referring to actually did involve companies that were, whose commodity price included bundle products. I mean, if you're referring to the suppliers that whose prices were significantly higher than utility default prices following the polar vortex. It was my understanding that in the cases that I'm aware of, that was in fact the price for commodity that those companies were charging. I'm not aware of any example of that price including some type of additional benefit other than the energy itself. And that's not to say that that wasn't the case. I think that the problem with the way purchase of receivables and utility consolidated billing work currently is that there's not a lot of transparency, and it's very difficult, if not impossible, for stakeholders such as OPC to understand exactly what is included in that price. Now, as far as the question that you asked, as far as how would we get at this, I mean, one of the ideas that was tossed around in the work group process was, to and OPC had asked early on in this proceeding for a reexamination of purchase of receivables, not just for supplier consolidated billing, but overall, including for utility consolidated billing. And one of the ideas that we had discussed in a work group, and certainly this was a non-consensus discussion, but was using the utilities default rate as a sort of proxy for what the commodity commodity price should be, or an estimate of what the reasonable value of the commodity price could be. And I think that to the extent that the commission was open to the idea of reevaluating the way purchase of receivables work, OPC would fully support exploring that more fully. But given the constraints that the work group was operating under, I think that what staff has come up with is the, frankly, only way I can see a workable system for purchase of receivables to work for supplier consolidated billing. And with the with the idea that we are also trying to adhere to the requirements of the PUA, we are trying to limit the level of distribution charges that might get sent back to utility. So with all of the various things that are being juggled in this effort to implement supplier consolidated billing, we believe that what staff has proposed is is really the only path forward.
All right. Thank you, Mr. Alexander. And I'll apologize to some extent for picking on you for that question. Thank you.
If commissioners do not have additional questions, I know we'd like to share some thoughts, and Commissioner O'Donnell was saving his from the first portion. So I'll turn to Commissioner O'Donnell first.
Thank you, Mr. Chairman. I hope I'm cogent. For years in the legislature, you could count on one to a handful of priority lien bills being introduced, and priority lien bills were typically not unlike this payment posting argument, in that it was usually one market segment or another, one industry segment or another, trying to get to the head of the line for payment in situations where payment may be at risk. Not exactly analogous, but close. The vernacular is different, but it was a turf battle, and that's what this feels like to me, a turf battle in terms of who gets paid first, who doesn't, who has the risk, and who doesn't. It's a risk-shifting debate, in my mind. And we have such constraints on the competitiveness of the utilities that it's almost like, wait a minute, what are we doing here? Our obligation is to, one, support retail choice, but two, to make sure that our utilities are viable, financially viable, and can continue to provide service of last resort in this competitive environment. And I don't think that these things are working towards that. I really don't think that. I think that, you know, we have such constraints on the affiliate relationship rules for our utilities. They can't package stuff. They have to offer SOS in a highly competitive environment. They can't, you know, use their home energy services affiliate and bundle it into their rates of SOS. They can't, even though people may like that service, as the suppliers assert. But to me, they're very, very, very different things. And I'm going to support the status quo ante. And I find the utilities arguments compelling here. And in both the bundling issue and the payment posting set of issues. And so to me, this isn't even a close call in my mind. I don't know if that was very cogent or not, but that's kind of where I am. I'm not compelled. I'm not moved to change anything in that regard.
Well, let's turn to Commissioner Herman, if you're ready, Commissioner Herman.
Okay. I agree wholeheartedly with Commissioner O'Donnell. I am not at all compelled that all ratepayers should be paying for delinquent Netflix charges or toasters or mini fridges or anything. I think these numbers can add up, and I just do not believe they should be bundled. If you want to bundle, and if you cannot or choose not to separate out your commodity, then you go to the end of the line. But I think that you know that if suppliers want to get their arrearages paid, then they will separate it for this purpose. And so I believe that's possible. And with respect to the payment posting priority, I think that we should stick with what we have. I think it's the fair way to go. I agree with Mr. Trout that this is that was a compromise way back when. And I believe that it remains appropriate today to reduce the possibility of disconnection to the greatest extent possible. Thank you.
Commissioner Richard?
Yes, thank you, Mr. Chairman. These were pretty weighty issues. I guess I'll just cut to the chase. I found that staff, I think, hit the right point on both issues. On one, the commodity versus distribution, Mr. Trout did make a very strong case, but I think the staff got it right with just trying to come up with a workable solution that recognizes that the commodity charge is an essential component to providing the utility service. So I think that pro rata approach it works for me. On the bundle charges, again, I think the staff got this one right for the same reasons that Commissioner O'Donnell and Commissioner Herman stated. I'm just not convinced that that ought to be part of a first in the line type of charge. And I think Mr. Seegers made a good point that today under utility consolidated billing, that those charges are separated out before the suppliers are paid. I think it's still workable, and so that's why I think I'm with staff on that point. Thank you, Mr. Chairman.
Thank you, Commissioner Linton.
Thank you, Mr. Chairman. I would agree that for purposes of payment posting, we stick to the experience that we've already had and use the process that we use currently. It is something that was hard fought from both sides a while back, and so I don't think there's been any suggestion that it isn't working currently, and so continuing to use it would seem to make the most sense. I think I'm on a bit of a different position with bundling. I personally don't think that this is an issue that is going to result in a higher amount of arrearage or charges that utilities will have to purchase. I think that a lot of that, there's going to be a lot of challenges at trying to figure out exactly what is in the commodity cost and what's reasonable for purposes of the commodity cost. And I don't know exactly how we would do that on the back end once a complaint is raised about what the commodity should have been that was purchased by the utility. I think that we've already filtered out consumers that are having difficult times managing and paying their bills. And so now we're dealing with a consumer that conceivably should be able to manage their accounts better and would be knowingly selecting a service that through the bundling gives them a lower rate. And so we should not have a lot of consumers in this group that are unable to make their monthly payment in full, in which case payment posting isn't really an issue because they're paying the bill in full anyway. So I think that the new types of products that we were hoping suppliers would bring into the market kind of start in this area. And for those areas where there's other types of products or services, they wouldn't be part of a commodity cost anyway. And finally, I guess for the questions that I was picking on OPC on, more so had to do just with the basic thought that for the consumer, when they only really care much about getting the bill and what's on it. So when they see a commodity price that's much larger than the SOS rate, some of them will complain, but if they understand what it is and why it's that price, they can pay it and they can afford to pay it, then they do so and all is well. But also utilities today are purchasing commodity costs that we've tried in the past before to backtrack to figure out where the price came from in terms of the purchase receivable, and we're unable to do it. And that was during other complaint proceedings and even as Mr. Auslander noted during the polar vortex proceedings, where even then we weren't able to figure out why prices were so much different among the different suppliers. So I would be more favorable or more supportive to the idea of bundling and keeping the payment posting to work with that so that it doesn't have to always fall to the back of the line. But I just think that there's other options there, and I don't see it as becoming the scenario that would create a very large amount of arrears for utility customers to purchase.
Thank you, Commissioner. With respect to the first issue, the payment posting, whether it be utility arrearages or supplier arrearages first, I am in the minority. I support the petitioner's proposal, which is supported by OPC staff and MEA. I recognize that we do have a balance here, a balance to ensure equity amongst the utilities and the suppliers, but at the same time making supplier consolidated billing attractive enough where suppliers would have an incentive to actually participate. It would be a shame if we issued regulations and suppliers did not take advantage of them. With respect to the second item regarding bundling, I'm in the majority of my colleagues here. I wholeheartedly support the concept of bundling. I think it makes it easy to market and to sell to consumers, and consumers like the concept. However, I'm very concerned with non-commodity products and services that would receive a top first order priority in payment. As Commissioner Herman noted, even if the Netflix account is just $10, and we're not talking about Windows, once you multiply that $10 by the number of customers you have, the potential for all other customers to bear any bad costs related to that is not insignificant. For those reasons, I support the utility and staff and OPC's position with respect to not allowing non-commodity services in the bundle. With that, we hope that we've provided the parties with some initial pieces of advice from the commission. At this time, I did promise we'd conclude by 2:30 this afternoon. I know we had one final issue to address regarding dual billing. We will take that up first thing tomorrow morning. Before we close today, are there any logistical questions or matters that need to be addressed?
Hello, Chairman. This is Ben Baker on behalf of staff. Just to verify, so for tomorrow, we'll start with with regulations related to POR and based off the decisions that we received today. And just to summarize where I believe the decisions are, and to correct me if I'm wrong, the commissioners are supportive of the eligibility requirements, and the majority of the commissioners support utilities paid first, and that bundled products bundled products must be unbundled or they need to be paid last.
That's correct. Bundled products should be, well, if I could just clarify my point on there, and perhaps the commissioners want to further elaborate. I think bundled products don't necessarily need to be disaggregated on the customer utility bill. However, on the back end, they need to be disaggregated for purposes of payment priority. I see nodding heads from my colleagues. Okay. Is that clear, Mr. Baker?
That is, and we will work on revising the regulations to implement those decisions.
Okay.
Thank you.
Thank you. We'll see everybody back here at 10 a.m. tomorrow. This meeting is in recess until 10 a.m.